Court will note the appearance of Mr. Bailey on behalf of the plaintiff, Mr. Zhang on behalf of defendant. This matter is before the court on the defendant's motion to set aside the referee recommended order of August 13, 2024. Mr. Zhang.
Good morning, Your Honor. I will rely on my pleadings, but I would like to point out that it took a lot of courage for my client a lot of therapy for my client to start talking about the abuse she observed or she endured from Mr. French, and for the referee to use it against her to punish her essentially for trying to speak up. I think it just sets a bad precedent for the future. It's discouraging the domestic violence victim from speaking up in the future. Furthermore, neither party has asked for a changing legal custody, and it is very inappropriate for the referee to essentially initiate a changing legal custody without either party asking for it. And third, regarding the school issues, the referee very much solely focused on just the academic records of standardized testing. And that shouldn't be the end all be all of all evaluation when it comes to school. Whether you have family in the area matters. Whether you have people who you're familiar with who went to a school, who went to the school and who are familiar with the culture and with the community of the school matters too, also. And it is referee has erred in not considering that or minimizing the effect of those factors in making his decision. Thank you, Your Honor.
Okay, thank you. Mr. Bailey.
Yes, thank you, Your Honor. Regarding the pleadings, we're going to rely on Referee Croteau's referee findings. We had 3-day evidentiary hearing. We had witnesses. We had exhibits. We believe he did make correct findings. Regarding Mr. Zhang's allegations of credibility being a big issue in this case, they were, but they weren't the sole issue in this case. This didn't decide school district or custody alone, but credibility was a big part. And Ms. French did not have any witnesses to corroborate her stories, and her stories changed at multiple points of these proceedings. They were never brought before your attention at the divorce trial. They were brought up at a CPS investigation, and then the stories changed over time. Regarding legal custody, although legal custody was not requested to be changed in a pleading, Mr. French did make oral presentation at the referee hearing that if the court found fit, he would take sole legal custody of the minor child. And regarding the school, while academic records were presented as exhibits and Ms. French failed to provide any witnesses or any exhibits about Ellsworth schools, Mr. French also had an expert witness from Michigan State, from the preschool, who was able to talk about the transition to Hazlitt schools for young kids, how the children get to have their instructor at Michigan State directly talk with the instructor at Hazlitt schools. And so it wasn't just academic records, it was transitions for children from preschool to kindergarten, and it was about the other surrounding benefits of the Hazlitt area. So, Your Honor, we don't necessarily have a right to object to Ms. French requesting a de novo hearing, but we believe 3 days of evidentiary hearing in a very thorough record, very thorough transcript, and very thorough findings are satisfactory for the custody, parenting time, and school districts of this minor child. Thank you.
Okay, thank you. Anything else, Mr. Zhang?
Yes, I'd just like to point out that the expert that was spotting from the MSU preschool was not she was not part of the Hazlitt School District, and she was a program that Mr. French unilaterally enrolled a minor child in, claiming to be a child care program, and later turns out to be a school district, or not a school district, but some sort of a preschool program, and that was not consulted with my client, and for Mr. French to be able to gain advantage by bypassing the joint legal requirement before the sole legal issue was changed, I think it's just inappropriate. Thank you, Your Honor.
Okay. Well, the court has reviewed the file thoroughly. I've reviewed the referee's finding as well, and obviously the defendant disagrees with the referee, but that in and of itself does not establish error simply because you disagree. The referee did find the plaintiff to be more credible in this case, and credibility is always an issue, goes to a lot of the factual issues the referee found, and that the plaintiff had presented more compelling evidence than that of the defendant, and that doesn't in any way attempt to minimize, or as Mr. Zhang says, punish her for coming forward. But the fact is, when the referee is presented with more compelling evidence on one side, he has to consider that, and he did in this case. The court, when I review this, I do not find that the referee made a factual or legal error in this matter, and therefore the court is going to deny the motion in this case. Mr. Bailey, you can do an order denying the motion submitted under 7-day notice. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
The court will note the appearance of Mr. Bland on behalf of plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to show cause. Ms. Henderson.
Thank you, Your Honor. Unfortunately, this is defendant's 5th motion to show cause. I would ask the court to remind plaintiff she still has an outstanding warrant for failing to attend the previous hearing. At this point, she continues to deny the parenting time to my client. Most recent denial occurred as recent as last week. At this point, we're asking for the court to schedule another in-person evidentiary hearing to which the plaintiff should bring the child, and the child would be in a conference room with an adult during the hearing. Otherwise, my client is not going to get the child. We're asking for her to be held in contempt. We're asking for the bench warrant that is currently out for Ms. Coolidge's arrest to be modified to be extraditable. For court's information, my client is in the process of domesticating the orders of this court in Indiana, but it does take some time, unfortunately, and Ms. Coolidge continues to deny him parenting time. We're asking for makeup parenting time of 6 overnights and 8 days. We're asking for attorney's fees, Your Honor. At this time, plaintiff has not made any payments on the fees she's already been ordered to pay. So in lieu of receiving the payment, we're asking that my client get credit for a total amount that has been ordered for Ms. Coolidge to pay, as well as the current attorney's fees, and to set it against any child support obligation that my client would have. Otherwise, he will never get paid by plaintiff. We're asking for in-person evidentiary hearing to address all of those issues, and we're asking that the child be presented for that hearing. Thank you.
Mr. Bland, are you contesting the matter, so you believe we need an evidentiary hearing? You're muted, Mr. Bland.
I apologize.
Nope.
Yes, Your Honor, we are disputing those matters.
Okay. In that case, the court will hold an evidentiary hearing. The court will do that again in person. In this case, the plaintiff will have to be present for that, and the court will order that she bring the child as well to that particular hearing so that the child's available to the court.
Judge, I would note at least that she wanted me to indicate that coming to Michigan is a hardship for her.
Mr. Bland, I don't care what her hardship is or problem. We've addressed that. She'll appear, or otherwise we will have her extradited and put in jail. That's her choice.
I'm not trying to quarrel with you, Your Honor, just indicating.
I understand. I'm just telling you.
That happened to my client.
I understand. I'm just telling you what's going to happen, or otherwise she'll find herself in jail.
Thank you, Your Honor. Would the court like me to prepare that order, or will the court be sending the notice with the date?
We'll be in touch with both your offices and set up a time when you're available.
Thank you very much.
Okay, thank you.
Thank you, Your Honor.
Have a good day.
Thank you.
9:13 a.m.
Court will note the appearance of Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt and request access to various passcodes. Ms. Henderson, did you get the answer in this matter in which she stated she had provided those passcodes?
We did, Your Honor. Unfortunately, the children's phones have 2 sets of passcode. One is to actually unlock the phone, and the second one is to the parental controls. That issue has been followed up on with Ms. Jazwiak upon having received the initial passcodes. Ms. Meredith Katz also weighed in on that issue on Friday, stating that both parents must have access to those parental controls as they need to monitor the screen time, the apps and websites that the children visit. And it's not just the parents' right, it's their obligation to monitor that. Ms. Jazwiak vehemently refuses to produce those passcodes. She states that Ryan can get the children their own devices to use at his home, or that he has to pay 1/2 of the bill. And again, Ms. Meredith Katz weighed in on this, stating that it does not matter who pays for the phone. It matters that both parents have equal access to the parental controls and that they're able to monitor the screen time limits and things of that nature. Ms. Jazwiak is receiving child support that can be used to pay the bill. It's not an issue of who pays the bill. It's an issue of each parent has the right to access that. And it should be noted to the court that the children are currently spending more time at Mr. Jazwiak's home due to him exercising the makeup parenting time he has been granted. So it's absolutely fundamental that he has access to those passcodes. Because Ms. Jazwiak vehemently opposes providing those, we're asking for her to be held in contempt, as this is a refusal to follow recommendations of Ms. Katz that both parties are to follow pursuant to a court order, and we're asking for attorney's fees in this matter. Thank you.
Okay, thank you. Ms. Jazwiak, you're muted. You'll have to unmute and then respond.
Okay. Can you hear me?
Yes.
July 26th was the last time I had any contact with Meredith Katz. She has not involved me in any of the meetings any conversations. I knew nothing about a conversation pertaining to the kids' cell phones. I received an email September 6th telling me that I needed to hand over the passcodes. And at the end of the email, Meredessa clearly states, if you have any questions, to reach out to her. I did. I responded that day with an email asking several questions about my children's safety concerns, if anything had taken place that I should be aware of, as to why Ryan needed the passcodes to the phones. I don't believe it's for good intentions. I believe it's to read conversations between me and my children. However, I never received any answers to any of my questions. It was kind of passed to the side. And I complied anyway by giving him the passcodes to the phones. So he is able to enter the phones. He is able to see what they're doing. The kids do have downtime on their phone. They do have app limits. They do have contact limits. Communication safety is on. Content and privacy restrictions are on. As far as the codes, not giving codes on the contact limits and app limits, those phones are linked to our Apple Cache and our iCloud. So I don't believe Ryan needs those passcodes. I also think this would be a great opportunity for Ryan and I to co-parent by deciding the limits together, and not Ryan putting limits at his house and then Chelsea changing the limits when they get to my home. That's something we should decide together. I never refused to give any codes. I simply asked questions I had no answers to. And I'm not trying to undermine anything that Ryan's doing, but rather work together instead of running to Meredessa every time that there is an issue between us that involves the children, as I am no longer included in anything that is happening.
Okay, well, I don't know where the breakdown was with Miss Katz, if there was, but you have a right to request that. And obviously it's stated that the parties would continue counseling with Meredessa Katz and would follow the recommendations. And I don't think that Mr. Jazwiak's request on having access to those phones is for any ulterior motive or anything other than for the, again, the supervision, monitoring of the children, which is important. So the court is going to order that all passcodes as necessary for him to monitor their phones would in fact be provided within 7 days of today's date. And so they would have access to those. The court would, at this point, I'm just going to reserve on attorney fees pending any further proceedings in this matter. And with that, anything else, Ms. Henderson?
I don't believe so, Your Honor. Thank you.
Ms. Jazwiak, anything else?
No.
Okay. You're free to go. Have a good day.
Thank you.
Thank you.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Kapscher on behalf of defendant. This matter is before the court on the defendant's amended motion for relief from judgment and motion to modify judgment of divorce. Court notes I have received and reviewed the answer as well in this matter. Ms. Kapscher, you can proceed.
Thank you, Judge. First and foremost, I just want it to be stated for the record that we came before this court a few months ago on our original motion to set aside the judgment of divorce.
Ms. Kapscher, I don't want to interrupt you, but you don't have to give me all the background. I'm well aware of it. I've reviewed the file in preparation for today.
Thank you, Your Honor. All I want to say is that my client would have no reason to say what he did at the pro confesso hearing if not for the 2-hour, 3-hour conversation that he had with Ms. Taft discussing the terms of the judgment of divorce, where she continually stated that she was fatally diagnosed. Again, Your Honor, we've been here before. I've stated this before. I wish no ill will on Ms. Taft. However, the fact of the matter is that my client entered into a judgment of divorce under the presumption that circumstances would be different at this time. Also, I just want to address specific things stated within Ms. Taft's answer. While she states that she never directly told Mr. Murphy not to have an attorney, she would often utilize the children. She communicates through them very frequently. She utilizes them to induce Mr. Murphy into complying with what she wants. So for instance, she would communicate that, Mr. Murphy shouldn't have an attorney, and they would talk to their father stating, we're really upset that you have an attorney. You should get rid of one. Mom already has an attorney. She also utilizes them when it comes to parenting time exchanges. She will initially try to communicate with Mr. Murphy. If he doesn't agree with her, she will then communicate with the minor children. A great example of this is an exchange location. Recently, the parties were trying to exchange the minor children. Ms. Taft violated the agreement twice. Mr. Murphy then stated, well, I'm not going to go by your agreement then if you're not going to follow it either. Then Ms. Taft called the minor children, who then coerced Mr. Murphy convinced Mr. Murphy into going by the agreement. This is a repeated action. Unfortunately, these minor children are being caught up in divorce and post-judgment proceedings because Ms. Taft continues to include them in this. For instance, as we stated in our motion, Mr. Murphy has continually tried to work with Ms. Taft. He did not get the overnights on 6:30 through 7:2, 7:7 through 7:9, 7:14 to 7:16, even though it's stated in her answer that he did get those. He didn't. He was trying to work with Ms.
I want to interrupt you now, but how does this go to your motion? You're bringing up all this extraneous stuff. Doesn't go to your motion to set aside the judgment.
Well, Your Honor, our motion is to set aside the judgment and in the alternative to modify the judgment of divorce pursuant to all the reasons stated in our motion. The first portion of our motion is to set aside pursuant to our original motion that we filed. And then the second portion is to state that in the event that you don't want to set it aside, that we at least modify it to comport with the changes in that Ms. Taft has not complied with the parenting time agreement, has not complied with the expenses agreement, which Ms. Taft states in her answer that it's actually Mr. Murphy that keeps shutting off the card. In fact, the agreement by the parties is that they utilize that credit card for all extracurriculars, and instead Ms. Taft charges her personal cell phone, all the groceries and gas on that card, and frequently maxes it out, which is why it's allegedly being shut off. So, Your Honor, again, there's numerous inaccuracies stated in this answer, and so we're asking for either the judgment of divorce to be set aside, or that we modify the judgment pursuant to our requests to incorporate the changes that we need. Thank you, Your Honor.
Thank you. Mr. Schaefer.
Your Honor, this is a motion to set aside the divorce judgment under Rule 2.612. And it certainly goes astray in a lot of ancillary ways that I don't think are relevant to that issue. Our position, there was no pressure. How does one pressure somebody not to have an attorney? And then we hear today new information not pled about influencing through the children, which is not supported in the pleadings or anything else. This is a remake of the prior motion. There's no new information herein. The only thing that they attached was the testimony from the pro-con. And again, the judge recognized that. The judge indicated that he was convinced that he approved the judgment, he understood it, and he signed it. This is an agreement that they negotiated, that it went into effect, and there's nothing in here of any sort of fraud at all. Even if you believe that there was a diagnosis, now the complaint is she didn't die. I mean, that's pretty draconian at best. And but that was not made. He made his own decision as to what he entered into, and it should be denied, and costs should be awarded to my client to have to go through this process a second time. We've answered all the other extraneous stuff, and I think it's a pure retaliation for the reason that the defendant has been charged with domestic violence. He has a PPO coming up later. So this is striking back out, trying to retaliate. We ask that it be denied and that reasonable costs and attorney fees be awarded.
Okay. Anything else, Ms. Capture?
I have nothing further, Your Honor. The pleadings speak for themselves.
Okay. As the court reviewed this file in preparation for today, the court notes the court did state at the prior hearing that allowed defendant to renew his motion upon new facts, which would establish his basis for relief from judgment. I do not see any new facts in the current motion that would cause this court to vacate the judgment of divorce. There's nothing new from what was previously alleged. Court does not believe that the motion meets, again, the threshold necessary for relief from a judgment. And as a result, the court will deny that particular motion. However, the court does note that the motion does raise issues concerning parenting time. Parenting time is always subject to modification, and pursuant to Shade v. Wright, the court has a right to consider that, and that's a much less burden in this particular matter. The court will refer the issue of parenting time and support to the extent that the parenting time is changed and has an impact upon the support, and refer that to the referee for a referee hearing. The court will not award cost at this time. Mr. Schaefer, you can prepare an order denying the motion to set aside relief, and then the court will prepare the order to send the issue of parenting time to the referee.
Thank you.
Thank you.
Thank you.
24 at 9:30 a.m.
Court will note the appearance of Mr. Sackrider on behalf of the plaintiff, Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion for allocation of proceeds from the sale of the property. Mr. Todd, after I read all the pleadings in preparation for today, I had some questions. As you had stated that your client had made mortgage payments just slightly less than $48,000 in this particular matter. But I note when I saw the other paperwork, I think attached to the answer, that the mortgage was paid off sometime. I don't know if you know when the mortgage was paid off, because I know the paperwork shows that the monthly payments were just under $450. So I'm looking at the time-wise and say, okay, it's hard to reach your $47,928.
Yes, Your Honor. To be 100% honest, I'm not certain when that exact payoff date was. However, I believe that the opposing party is in agreement with that 47,000 number, and we do actually have, actually, I believe it's the opposing party's Exhibit 2 that's actually the verification for that.
That's your understanding, Mr. Sackrider, that the $47,928.83 is accurate?
That is our understanding from the June 1st, 2018 Homestead Savings Bank letter. I would note that we did the same calculations for the mortgage and the note. It's not exactly clear when that was exactly paid off, but the only evidence I have is the Homestead Savings Bank, and I don't have any other proofs on that matter.
Okay, thank you. Mr. Todd, you can proceed with the rest of your motion. It looks like the issue is resolved, so the court would order that the defendant would receive a credit for that amount, the $47,928.83 against the proceeds from the sale of the home.
Thank you, Your Honor. Your Honor, for the balance of the motion in this particular case, there were expenses incurred which substantially increased the equity of the property and go beyond standard maintenance. Just highlighting a few: bathroom renovation, a pool liner, the new roof. Those all go substantially beyond what standard maintenance would be. We have outlined each expense individually, which comes out to $22,000. Additionally,
okay, Mr. Todd, I did look back at the judgment and reviewed that, the judgment from October 3, 2006, making your client responsible for the maintenance on the house, etc. It did not state that he would be reimbursed for any improvements to the house. So how does the court go and say, yeah, you're entitled to these when you did it unilaterally?
Well, and Your Honor, that's exactly why we're here today is, we're not filing a motion for contempt or anything. We're simply having the court weigh in as it amounts to that increase in value. And I guess beyond that, there is a second section of expenses related to sell the property. And we believe that that portion is more explicitly stated in the judgment, indicating the net equity. And those expenses are $2,740, and those are direct expenses related to selling the property.
Okay, thank you. I had that as one half being 1,370, so that would be accurate.
Correct. Yep.
Okay. Mr. Sackrider, any response?
Thank you, Your Honor. I believe the judgment of divorce is pretty clear. This was signed in 2006. The marital home located at One Road shall be sold. Next paragraph, it doesn't limit payments to maintenance like defendant stated. It says defendant shall be responsible for all payments associated with the home prior to its sale, including but not limited to mortgages, taxes, insurance, maintenance. There was no receipts or proof of payment attached to that motion. My client does have evidence that at least a portion of those costs being claimed were paid by insurance. It's for all of those reasons, Your Honor, we would ask that this motion be dismissed and that plaintiff be awarded attorney fees in the amount of $1,000 for having to file the motion to show cause to obtain a realtor to force the sale of this property since the judgment of divorce in 2006, as well as respond to this motion for allocation of cost today, Your Honor. Thank you.
Okay, thank you. Well, in this matter, as you stated, the parties do acknowledge the amount of approximately $48,000 to be reimbursed. Court does believe that, again, the costs associated with sale, that of one half of that being $1,370 would be reimbursed to the defendant in this matter, because the parties are each responsible for obviously those costs of sale, et cetera. But as to the other expenses sought to be incurred or sought to be, again, reimbursed, again, there's no provision in the judgment that would award that. If he would have at the time came and filed a motion, the court could have addressed it at that particular time before he incurred those costs. He did not. So he basically unilaterally incurred those. The court will not order reimbursement of those particular expenses. The court can only enforce the judgment, and that is the written order of the court, and I will do so. I'm not going to award attorney fees at this time, and I'll let you, Mr. Todd, prepare the order.
Thank you, Your Honor. Your Honor, I apologize. One question. There was an $1,000 deposit paid in good faith to sell the property.
I didn't understand that at all from your motion.
Yeah, a little bit odd, I guess, in certain respects, but my client did pay Mr. Sackrider $1,000, I believe, to be put in escrow, in essence, as a good faith showing that he was trying to diligently sell the property. I guess we're just respectfully requesting that $1,000 be returned or, applied to, returned in essence.
Mr. Sackrider, again, based upon the motion, I have no idea what that money's for, why it was paid. Could you enlighten the court?
I agree, Your Honor. I don't know why it was paid. My staff took a $1,000 payment from him. It was not clear what it was for. The payment is sitting in a trust account. It would become part of the closing of this property, Your Honor.
The court, what it'll do is I'm not going to make any ruling on that at this time. We'll wait and see how that flushes out at closing, and then we'll deal with it at that time if we need to. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you, sir. At 9:39 a.m.
Good morning to all of you. Ms. McNiff, I look and see, do you have two clients in this case or what?
Your Honor, I do not. We've hired a new associate.
Oh, okay.
Yeah, her name is Aya Farhat. She is sitting next to me, and she's just learning until she gets her bar results.
Oh, well, great.
Should I turn the camera so you can say hi to her?
Yes, if you would.
I will do that. Hi, I'm Aya.
Hello. Well, I was just going to tell you at some point, if you get opportunity, you can come into my office and I'll give you the full unabridged scoop on Miss McNiff. And, you probably know already, but in case you don't, you probably need to be enlightened.
Oh dear, I'm going to keep her far away from your office, Your Honor.
After that point, she's going to be barred from Battle Creek, huh?
Thank you for letting me sit in.
Okay. Court will note that this matter is before the court on the plaintiff's motion to modify child support. Obviously, we don't have anything as up-to-date records or anything like that. The intent was, Ms. McNiff, to refer to the referee for a hearing, and then we can hopefully get all that information at that time.
That was my thought as well, Your Honor.
Okay, thank you. We'll do the order and refer it.
Thank you, Judge.
Yep, have a good day.
We're at 9:42 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. Court will also note the appearance of Ms. Henderson as the GAL. In this particular case, the court does not note
Hold on, where's Kyle? I'm sorry, he must not have joined. It says he's joining.
Oh, okay. I was just getting ready to state that he had not joined us yet.
He's on, I clicked and it says joining, but he's. Can you hear me? Please connect to audio. Please connect to audio.
I'm sorry, what's that?
Okay, so you can hear us now, is that correct?
Yes.
Okay. Court will note that this matter is before the court on the plaintiff's objection to referee order, as well as the motion for parenting time. Ms. McNiff, I know in reviewing the pleadings, you said that Ms. Wallace and Dr. Haugen had not testify. I didn't see any reason as to why they didn't testify. What was?
Well, Your Honor, this case is been continued. We have a status conference that is upcoming. We've had a lot of hearings. I don't believe that we're quite finished as of yet. There have been so many issues involved and so many therapists involved that I think that we do need to continue the referee hearings. And I believe at the next status conference that may very likely happen. However, in the meantime, this court entered the ex parte order that required Mr. Schmidt to stay 20 feet away from Ms. Galt during attempted parenting time exchanges. He's already violated that. We have a PPO hearing before Judge Yost Johnson coming up at 11 o'clock this morning as a result of his violations of Ms. Galt's personal space and his attempts to reach into her car in order to grab the child. At this point, the child, Abigail, has not been going to parenting time for quite some time. Now, their son, Ben, is refusing to go as well. And he's become more and more afraid of his father as there's been police intervention. Mr. Schmidt has been inappropriate with the police, calling them.
I'm aware of that. You put it in your motion.
Yeah. So. He's just been incredibly inappropriate, and the escalation has been significant. So I think we're going to need a reset with this case. If there's going to be even supervised parenting time, there needs to be a trust building period for the child where he can be assured that dad won't yell at him, dad won't yell at mom, dad won't try to force him, dad won't yell at police officers, dad won't swear. And so we're asking that there be a suspension of parenting time for now until we can get back in with referee Snyder and see if we can come to some kind of resolution where we can help Ben and Mr. Schmidt to heal that relationship, because it's definitely, it was improving for a period of time. And now with the recent conflict, it's back to being as bad as it ever has been.
Okay. Mr. Schmidt, what's your response?
I disagree with her motion. Would you like me to go through the motion with you?
Well, you can give me what your response is. I don't need to go through it paragraph by paragraph, but you can respond.
Okay. Yeah, her saying that I've been out of line with my son. I showed up to a gas station to pick up my son, and 2 police officers are there because Miss Galt called them there. They tried to intervene and get in the way of me seeing my son. I went there to pick him up. They did not let me see him. And then since then, she has made obscured things that I say that I've done that aren't true. I just disagree with everything.
Okay. Well, it sounds like, I guess, I'll ask Ms. Henderson, do you have anything to add to this?
Yes, Your Honor, I was able to speak with the minor children twice. In fact, the second meeting was requested by Ben. And Ben has been very clear and adamant. I could visibly see that he is distraught anytime the topic of parenting time is being brought up. His therapist has been pretty clear in her recommendations that a reset is necessary. Ben does appear very afraid of his father, and unfortunately, that is a step back from where we were just months before this time. It does appear appropriate per the recommendations of his counselor to suspend parenting time, given the fact that it appears to be very harmful for Ben until such time that more testimony can be taken at the status conference on November 15th, Your Honor.
Okay, thank you. Well, what the court's going to do is obviously court takes these matters very seriously, and there's issues apparently because I've entered the ex parte, which would put some restrictions and try to, again, to make this occur in a more smooth and reasonable fashion. That apparently hasn't helped. What the court's going to do is you can talk to, when you talk to referee Snyder at your status conference. When is that coming up, Ms. McNiff? Approximately?
November 15th.
Okay. What the court's going to do is I am going to temporarily suspend parenting time and order that if you would have Mr. Snyder expedite that hearing, at which time you can present Ms. Wallace and Dr. Haugen's testimony that allow the referee to review, again, the prior testimony and transcripts, et cetera, in this particular matter, and have a full understanding of what we need to do going forward. And then you can enter an order at that time. But I would like it expedited so that we can get this matter resolved, because I don't like to suspend parenting time unless I have to. Okay, Ms. McNiff, you can prepare that order.
I will. Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Your Honor, I apologize for interrupting. Is the court addressing the objection as well, or is that encompassed in the ruling? Because I know
Well, it's encompassed. If I've
Okay.
suspended, that kind of
Okay,
takes
I just
care
want to
of
make sure. Thank you.
Okay. Thank you.
Thank you, Your Honor.
At 9:51 a.m.
Court will note the appearance of Ms. Shadowins on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. Ms. Thomas has filed a motion to withdraw in this case. Ms. Shadowins, are you opposing the motion?
Not opposing the motion, Your Honor. I just would note that I believe we have mediation scheduled for Friday, which I'd like if we could continue that on the calendar.
Okay.
Your
well,
Honor, Your Honor, if I can interject, I did have conversation with Mr. Martins over the weekend, and he and I have agreed that I will withdraw effective next Monday, which will allow mediation.
Okay. Well,
If the
great.
court's okay with that, it'd be October 7th would be.
I'm fine with that. You can submit under 7-day. It won't get entered until after that date, and you can put that you're withdrawing as of that Monday.
Okay, perfect. That's what we'll do.
Shadowin, that doesn't interfere with your mediation then.
Thank you.
That was my whole intent. That was our intent.
Okay, thank you. You're free to go. Have a good day.
Thank you.
24 at 9:54 a.m.
Court will note the appearance of Mr. Umloff on behalf of defendant. As just stated, it is 9:54 a.m. This matter was set for 9:30. It was set on the defendant's motion to terminate spousal or child support in this particular matter. Court would note that the allegations are that the child, Brent, is 18 and graduated last spring, and therefore it should be terminated, and doesn't appear to be any opposition, so the court will grant your motion in this matter. Mr. Umloff, you can submit an order under 7-day.
Thank you, Your Honor. And will the termination of child support be effective the date of the minor child's 18th birthday?
Yes, that was just recently, wasn't it?
It was. I won't say the date because we're streaming on YouTube,
That's
of course.
fine. Yeah, you can have that and just state that it'll terminate as of that date.
Thank you, Your Honor.
Okay, thank you. Have a good day.
Same to you.
9:59 a.m.
Court will note the appearance of Mr. Snyder on behalf of the plaintiff.
Defending, Your Honor.
Good morning.
Good
This
morning.
matter is before the court on the plaintiff's motion to enforce and amend the final consent order for custody, parenting time, and support. Mr.
Your Honor,
Snyder.
this is defendant's motion. I represent defendant Maya Moore.
Oh, okay. I'm sorry. Had down that it was plaintiff's motion on our notes.
That's okay.
You can go ahead and proceed, Mr. Snyder.
Yeah, so this is our motion. The court ordered a consent order earlier this year for the party's minor child. It said mother gets custody Saturday noon to Wednesday noon. It did not have a place to meet for the parties. They live a while apart, and they're having issues with the meet place and point.
Okay, I note that you have in your motion at least that they've been meeting in Portland. Is that at a particular exit at a McDonald's gas station?
Gas station, grocery store, yes.
Okay.
And that worked for about a month. And since March, April, we've been having a lot of issues here.
Okay.
Plaintiff fails to show up, is late.
Okay, Mr. Luke, is there any problem with meeting at the location at Portland, that gas station?
Good morning, Your Honor.
Good morning.
Time this morning. I am requesting an adjournment this morning. I would like to meet with an attorney to discuss my options and establish representation. Thank you.
Okay. Well, Mr. Snyder, typically in these cases, I do allow, if a person wants representation, to at least a slight adjournment. So what I'll do is I'll adjourn the matter to next Monday, same time, 10 o'clock next week. Okay?
Your Honor, Mr. Luke had plenty of time to consult with an attorney.
I understand, but again, I don't want to cut off the opportunity to be represented, so I will adjourn the matter 1 week.
And we are asking for attorney's fees and costs, Your Honor.
Okay, we'll address that next week.
Thank you, Your Honor.
Okay, thank you.
Thank you. At 10:02 a.m.
Court will note the appearance of Ms. Paisno on behalf of the defendant. This matter is before the court upon the defendant's motion for appointment of reintegration therapist. Again, previously the court had ordered that the parties would go to the Avalon Behavioral Health, and it's now my understanding based on the motion that they do not do reintegration counseling. Is that correct, Ms. Paisno?
It is correct, Your Honor. I had a conversation with that office staff trying to set something up after my client was having some trouble getting records and setting an appointment, and they advised me that they do not do that type of therapy, and nobody in their office would be willing to help in that situation.
Do you have a recommendation, Ms. Paisno, as to who, or do you have to find?
Your Honor, there was actually 3 people I was going to give to the court. One is Margaret Hunter. I know the parties had used her in the past, but it didn't get very far. Rebecca Walker, who is at Kalamazoo Psychology, does reintegration counseling. And then there's a Kimberly Wisdomdorf Houghton Keeper out of the Hastings Battle Creek area. That's my understanding that she is able to do that as well. So I would ask the court order one of those 3 people.
Okay. Mr. Spring, do you have a problem with either of those 3 doing the reintegration?
Yes, Your Honor. I can't afford counseling right now, so this isn't going to be covered by insurance. So there was an order previously that Ms. Parr would pay 100% of the bill, but she never did. So I was settled with a debt. I simply can't afford another bill right now.
Okay. Ms. Paisno, is that accurate that she was supposed to pay for this?
Your Honor, I am not aware that she was supposed to pay for the counseling for the children. This court, when we entered the reintegration order, didn't specify who was required to pay. I'm not aware of an order previously, but it could have been before I was involved.
There could be. There's been a lot of orders in this case. So
correct.
If what the court will do you have a problem with Ms. Walker or Ms. Houghton Keeper, either one of those, Mr. Spring?
Yes, we tried with Hunter.
I didn't say Hunter. I didn't mention her.
Oh, I'm sorry.
I mentioned Ms. Walker, Ms. Houghton Keeper.
I don't have a problem if it's Ms. Parr and one of the children or 2 of the children, but a lot of the counselors do not like to do that.
Again, that they're saying they saying they would do reintegration counseling, and so if they say that, we'll take them at their word. Do you have a preference, Ms. Paisno? Ms. Walker apparently is closer. I mean, she's in Kalamazoo.
Your Honor, I don't have a preference to either one.
Why don't we try using Ms. Walker, and the court will reserve on the payment of that. I think there may have very well might have a vague recollection that the court had previously ordered Ms. Parr to pay for that counseling. So you might have to go back through the file and find that, but I'm just going to reserve at that at this point because I think there was an order.
You know, actually, Your Honor, the defendant shall pay any costs associated with reunification counseling that's not covered by insurance. That's back from June 30th of 2023.
Okay. Why don't you just, in this order, just so Ms. Walker's well, is to reiterate that in this particular order. I would order that the parties would contact Ms. Walker's office within 30 days of today's date to start that reintegration.
Thank you. Your Honor, and the other part of my motion was, it's my understanding that the minor child, Maria, is not in counseling and only Lucy's in counseling. With Avalon Behavioral Health, and I would just ask that she be required to attend counseling for the previous orders as well.
Well, the court will order that. That's no problem. We'll do that, and you can conclude that in your order.
All right, I appreciate that. Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
You too. Thank you.
2024 at 10:08 a.m.
Court will note the appearance of Ms. McKenzie on behalf of the plaintiff, the defendant appearing in pro per. There are 2 motions. Motion for order for Family Children's Services to supervise the parenting time, and for plaintiff's motion to dismiss the defendant's motion for custody. Ms. McKenzie.
Thank you, Your Honor. I'm asking the court to regard these motions as unopposed because no answer has been filed.
Well, I'm going to let her respond.
Then I'll go forward. Thank you, Your Honor. With regard to the motion to dismiss the August 1st, 2024 motion regarding custody, the Vadvarka standard was not met. I did attach a copy of Ms. Frederick's August 1st, 2024 form motion regarding custody. And
Ms. McKenzie, who referred it to the referee for evidentiary hearing? Did the court, or was it referee?
I think it was the referee, Your Honor.
Okay, go ahead. When I was reviewing this, I didn't have a recollection of the facts, so I'm thinking my thought, well, I didn't refer it because I didn't recall the facts.
Correct. I just recently got in on a case. There is a long history in this case, but I think that it was the referee after he entered a temporary order in July.
Okay, go ahead.
So, but I don't think that the proper cause or change of circumstance has been shown in the paperwork filed on August 1st, 2024 by Ms. Frederick. She's making allegations, but she did not explain in detail what has happened. And using FOC Form 87 entitled Motion Regarding Custody, it requires in paragraph F, like Frank 5, that a detailed explanation be given. That wording is simply consistent with the requirement of Vadvarka that something spell out what has happened since the entry of the last order to make it, to entitle the defendant mother to another evidentiary hearing. She's filed motions for custody in the past and has failed to appear for her own motion for custody. So the problem is that Vadvarka not being met, and the standard also in 722.271C indicates the authority of the court, as the court is aware. And in 722.27 parent 1C, it indicates that a limitation or it gives the court a direction on when the court is able to amend or modify previous judgments. And it indicates that a modification or amendment of a previous judgment or order has to be for proper cause shown or because of change of circumstance. That is the defendant's ticket into another evidentiary hearing. That has not been properly pled. Vadvarka standard has not been met. And we're asking the court to cancel the evidentiary hearing now set in front of the referee for October 9th, 2024. Regarding the defendant's August 1st, 2024 motion, we're asking the court to cancel that, and I will enter an order rescinding that privilege because the Vadvarka standard has not been met. We're also asking for attorney fees and costs, $400 in relation to this single motion.
Okay, well, argue the other motion as well, and then I'll have the defendant respond.
Thank you, Ryan. Your Honor, on July 19th, 2024, an order was entered giving Ms. Frederick supervised parenting time, and the order provided that the supervisor be the plaintiff or the other designee. And because she has made false CSC allegations against my client back in April, naturally and properly, he was unwilling to be the supervisor, but he has sent his designee. Most often it has been his grandmother, Mary Hopkins, Mrs. Mary Hopkins, and she has appeared to supervise the parenting time awarded in the July 19th, 2024 order. But in this particular matter on September 4th, we have multiple allegations of failure of a violation of the parenting time order, the July parenting time order by my client. However, when the time came on September 4th, the defendant mother said that her grandmother was unavailable. She had made arrangements for her own grandmother to go ahead and be the babysitter, and the grandmother mysteriously was unavailable on September 4th. And so Ms. Frederick said, hey, my new boyfriend would be supervisor. So the plaintiff father did allow this only for...
Oh, Ms. Frederick, don't interrupt. You have a chance to speak later.
I'm sorry, my child grabbed the phone.
Go ahead.
Only for the reason that the referee had admonished the parties at the last referee hearing that both parties did need to comply with the order, the court's orders. But on September 4th, the defendant mother took videos of the children while she interviewed them, and she was coaxing them to say derogatory things about their father after the children returned home on September 4th. She texted the plaintiff father saying she was going to quote unquote roast him with the videos. So September 7th, parenting time came around, and the plaintiff father sent his grandmother, Mrs. Mary Hopkins, as a supervisor, and Ms. Frederick simply refused to allow Grandma Hopkins to be the supervisor. So no parenting time occurred. Defendant mother filed another complaint for denial of parenting time. And she also indicated on that day that on September 11th that she was not going to allow either Mr. Hopkins, plaintiff Warren Hopkins, to supervise. She wasn't going to have any part of Mary Hopkins supervising either. And the fact that she's not accepting the designee of the plaintiff simply indicates that she cannot operate within the parameters of the referee's order. So I'm suggesting that if parenting time is even to continue, the best interest of the children, two young boys, require that a neutral third party be utilized, and that would be Family and Children's Services. And I'm asking that because she is refusing appropriate adult supervisors who are familiar to the children, that she be required to pay, both use and pay for the services of Family and Children's, and that the exchange for the parenting time occur at Family and Children's Services. So I'm asking the court to enter an order requiring the defendant mother to use and pay for Family and Children's Services, requiring the parties to make the exchange of the children ages 4 and 6 at Family and Children's Services, and granting attorney fees and costs of another $400 to Mr. Hopkins. Thank you, Your Honor.
Okay. So you have no problem with Ms. Hopkins if she continues? Ms. McKenzie?
But if Mary Hopkins continues as
Yeah.
supervisor? Not at all. No, she
Okay.
is an appropriate supervisor. And what is even better is that she's known. She has contact all the time with the little ones.
Okay,
So
thank you.
she is an appropriate supervisor, and she is a sensible individual known to the children.
Okay, thank you.
Is my client's relative.
Well, one reason I ask is Family and Children's Services has very limited amount of ability to supervise, and it's very stilted when they do. So,
correct.
With that, Ms. Frederick, what's your response?
My response is Mary Hopkins is not appropriate in my eyes. We have family on my side that the children know very well, as much as they know on their dad's side.
Let's just not say she's not acceptable.
Mary,
Tell us why.
okay, so back in 2021, or back in 2019, sorry, Mary and Warren Hopkins attacked me with my 7-month-old Jaden Hopkins, our child that we have in common, in my hands. Mary bit my hand, trying to get me to drop my child. I made a police report. Still to this day, I have a scar on my hand from her biting my hand. She coaches the kids to say certain things to me. They don't want to talk around me when she's around. She gives them the evil eye. She instigates with me, tries to cause arguments with me. She's just not appropriate. It's just a game. It's just a game. I don't understand why Warren himself can't do it, or one of my designees. My boyfriend, I never said my boyfriend could supervise. I don't have a boyfriend. It was a third party that's a friend. My grandma wasn't able to get up in the truck. She had a doctor's appointment that day. My grandma is able from here on out. It was just that day she had a doctor's appointment, and I didn't know. But as far as Mary Hopkins, I have videos of her coaching the kids and whatever else. So she's done nothing but cause problems, and it's just not a good idea for her to supervise.
Okay, well, anything else, ma'am?
No.
Okay. Well, the court in the prior order did state that the plaintiff could again designate, is my understanding from the referee's order, that either the defendant could supervise or the designee in this matter. Was that the plaintiff's designee or the defendant's designee, Ms. McKenzie?
I'm reading that as Mr. Hopkins designee, Your Honor, because it's all in the same paragraph.
Okay. What the court's going to do, the court will appoint Mary Hopkins as the supervisor in this matter.
Absolutely not.
Well, ma'am, you don't have a choice. I'm ordering it. So you don't comply with it, you could end up in jail if you want to go that route. So it's your choice. It's your choice, ma'am. Court will.
She just denied. She disconnected from the. I'm not sure she got. She's no longer on our hearing. In our hearing, Megan Frederick is no longer in the hearing.
Okay. Court will note that it's 10:20 and apparently she's disconnected. The court is going to order that the designee would be Mary Hopkins. Court is not going to. The court will note that the fact finder, the referee, had apparently made a preliminary determination that there was a proper cause or change in circumstances. I don't know what the referee was looking at that particular point, but the court's not going to intercede and again, take away the referee's discretion in this matter. It may be at a future point, depending upon the outcome, that the court does have to review it as a result of de novo, but not at this point. So the court will allow the referee evidentiary hearing to proceed in this particular matter. And the court will just simply reserve on cost at this time. And you can prepare the order, Ms. McKenzie.
Thank you, Your Honor.
Thank you.
6 a.m.
Court will note the appearance of Ms. Storm on behalf of the defendant in this matter. The matter is before the court on the defendant's motion for modification of domicile, modification of custody, parenting time support. Ms. Storm.
Thank you, Your Honor. I'm sure the court's already read the motion. So briefly, we have a situation where we are locked in this repeating pattern with mother, where we have instability and inconsistency in the custody issues regarding their minor child, specifically the child's mental health and other medical needs. There was an incident where mom refused to refill a prescription that was necessary for the child. The child then had withdrawals from that, and it got so bad that the child had to be taken to the hospital, and then she was kept an inpatient for a number of days. This is a pattern by mother where things, as soon as things fall apart, she's back on, promises are made, I'm going to change. And while the eyes are on her, like with a CPS investigation, she's great. But once the investigation or the eyes are off of her, she lapses back into instability and inconsistency. And this is having a negative impact on the party's child. She has asked to live with her father. She knows that being with dad is going to be a more stable place for her. My client has the ability to have the child live with him. He's been in a stable home for quite some time now, and is more than willing and able to ensure that the child's medical and educational needs are being met. So we would ask that the court consider our motion and likely set it for an evidentiary hearing.
Okay. Well, we don't have the plaintiff. Do you know at all why the plaintiff isn't here, Ms. Storm?
She had indicated to my client that she kept indicating that she didn't have notice for today's hearing, even though she had received all of the notices that I had sent prior, as I had some scheduling difficulties. And so having sent this in advance, she even confirmed via text with my client that she knew the hearing was for today. I'm not sure why she's not here or not participating in today's motion hearing.
Okay. Well, the court isn't either. I just didn't know if you knew, and it is now 10:29 a.m. It was set for 10 o'clock. I will allow you to proceed with an evidentiary hearing before the referee in this particular matter. I would state, based upon my reading of the motion, however, it's a very weak motion at this particular point, but there is enough there to proceed with the evidentiary hearing, and hoping that the plaintiff would respond and give us some indication, but she hasn't. So allow you to proceed, and we'll refer it to the referee.
Thank you, Your Honor.
Thank you.
Your
I
Honor.
will note that this matter is before the court on the defendant's motion to modify custody, parenting time, and support. Mr. Miller,
Yes, sir.
go ahead.
Hey, is April joining us?
She is.
Okay. Your Honor, on June 10th, you awarded the plaintiff, and we agreed to let her have supervised visits with our minor child, Keon. Since that time, Ms. Keeler has participated in one visit and has not done any Wednesday visits. She has not reached out. I haven't got any phone calls to try to get set up a time or to pick up or anything like that. So she's refusing. Sorry. She's refused basically to participate in these visits. She has also, since the last court hearing, looks like she has 2 driving while license suspended and 1 open case of driving under the influence. Because Ms. Keeler has not participated in any visits and doesn't appear to be going to any time in the near future, that with her continued alcohol use and drinking and driving, we just don't feel it's necessary to have on record that she should have any kind of supervised visits or otherwise. Therefore, we'd ask that you remove those supervised visits from the order.
Okay. How does the fact, and I can't say that if she's obviously incurred some additional DUIs, that won't have an impact, but if she has a supervisor, how does that impact the visits if there is in fact a supervisor?
Well, she's not participating at all. She hasn't reached out to participate. She hasn't tried to.
Well, if she doesn't participate, then she forfeits the parenting time. So that's her option, I guess, at that point.
Yes, and we'd like to have that on record, that the order be changed. I mean, I don't want him looking over, questioning, oh, is today going to be the day she tries to come in? Because at this point he doesn't want anything to do with her. I mean, she hasn't shown any effort. She's not trying to show any effort to be in his life, or at this point I just feel she's a danger, to his well-being.
Ms. Keeler, what's your response?
That's not true, Your Honor. I have reached out to my son. I don't reach out to the father at all. I have reached out to my son. I have seen him. I have talked to him. I have texted him. So that is not the case. And all the other drive-in while licenses are suspended, they've been thrown out. So all of that is irrelevant. And like you said, it is supervised. And every other weekend, a teenager does not want to sit at his grandparents' house all weekend. So there is complications with that sometimes. There's also been football camp during my time where I've allowed him to go to camp instead of coming and spend time with me. So there are reasons why I am missing some of my time, but it's not because I want to miss out on my time with my son, Your Honor, at all.
Okay. Well, the court had previously ordered a supervised parenting time. Again, I don't know what the particular issues the defendant has brought up, but brought up some issues in that matter, but that would not impact supervised parenting time, as that there would be a proper supervisor. What the court will do in this matter is I'm going to deny the motion. There's not a basis to eliminate the supervised parenting time. Only thing I would do is order Ms. Keeler that when you do have the parenting time arranged, if you do talk to the child and arrange it, that you confirm that with the defendant so that he knows what's happening in this matter, because you need to have that communication so that he would confirm with him when the parenting time is going to occur, and obviously that you'd have the supervisor present for those particular visits. And Mr. Miller, I'll let you do a order that simply states that that she would communicate to you when that parenting time is going to occur.
Sounds good, Your Honor.
And you can submit that under what they call a 7-day notice of entry. If there are no objections, then the order would be entered. So, okay.
Yep, thank you.
Thank you. You're free to go. Have a good day.
You too. Thanks.
24 at 10:36 a.m.
Court will note the appearance of Mr. Robinson on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to change custody. Mr. Robinson.
Thank you, Your Honor. I think our pleadings pretty much set forth our reasons for the necessity of an order changing custody. Mr. Shelley hasn't had any contact with his son in over a year as a result of severe beating he gave his child. The son is absolutely terrified of his father. He doesn't want to talk to his father, doesn't want to see his father, doesn't want to be with his father, who was supposed to be on probation for another 8-9 months, but they terminated his probation early without notice to my client or to the boy. And what I'm asking the court to do is set this matter for a brief evidentiary hearing, perhaps parties only, so that we can get an order keeping him in place with his mother.
Okay, thank you. Mr. Shelley, you're muted. You'll have to unmute, and then what's your response?
Please unmute. Click on the microphone.
If you scroll down to the bottom of your screen, there'll be a microphone that'll come up that says audio on it. And if you hit that, then you're going to unmute yourself.
Fortunately, I think I'll place you guys in the waiting room and then I will bring you in after.
Give them a few more moments and then we'll go ahead.
I'll try to check someone else in maybe.
Yes, go ahead.
Please unmute.
Okay, you're going to have to disconnect from the computer because we're getting feedback, and then
This is
you can appear.
Can you hear me now, Your Honor?
Yes, we can.
Okay, we're gonna kill this.
But we may be only hearing you through the phone. I don't know if we can hear you through the computer.
Disconnected.
Nope, we can't hear you now, sir.
I
What you're
think
going to have to
it
do
was
is,
disconnected.
yep, join by phone and then shut off your computer. We can hear you on the phone, but we can't hear you through your computer.
Let's see. Oops.
Join by phone, sir.
I sent him the phone number.
Hello?
Hello, Kelsey.
Yeah?
All right, so it'll be just a few minutes, okay? I'm gonna put you in the waiting room.
Yeah.
Thank you. I did not rejoined.
Mr. Shelley, join by phone, please. You're not getting through on the computer. And once you join by phone, then disconnect the computer.
All right. I'm going to put you in the waiting room. We'll call another case and then we'll bring you guys back in, okay?
Okay. It's cold.
Miss Daniel, do we need to wait until you're done eating?
No, I'm good. I can wait.
Well, we can't, so you'll have to.
Yeah, no, I'll wait to eat.
Okay. This matter is before the court on the plaintiff's motion requesting additional time to present evidence. Why, Miss Daniel, do you need more time and did not produce the evidence when you had your hearing?
I didn't receive anything in the mail to show me that I only had 21 days. Normally they told me I had to do a change of address for me to get mail. So I'm like, okay, so I did that. And then I was like, okay, now I can bring the evidence. It's like, no, you have to sign a motion or ask for more time. I was like, oh, okay.
This is a referee hearing, isn't it?
This is to bring evidence to the trial.
Okay, hold on.
Yeah.
Miss Woodard, is this set for the referee?
No, this is a trial. It's a DM trial. There was a case scheduling order entered on May 29th. Discovery until July 1st, mediation in July with a settlement conference in August.
Okay. Well, Ms. Ms. Daniel, you've missed the deadlines by a long shot. This isn't closed. So the case scheduling order was from May 29th. It told you in that case scheduling order that you had the 21 days from the date of the first mediation that occurred in July, and you haven't complied. You're now well over 2 months past the deadline. You could have filed anytime in May from May on. So why should the court give you more time when you haven't basically done anything in 4 months?
Because like I said, I didn't get the notice in the mail. So that's why if I would have got it, you would already had the evidence because I have everything right now.
Okay, let me ask Mr. Daniel. Mr. Daniel, do you oppose more time to provide evidence in this matter?
I oppose.
Okay.
It's done.
Okay. Well, what I'm going to do is, again, those orders are again put in place. And at the time that we had the scheduling conference, we informed you that there would be dates that you had to comply with in the order. And we stated at that time, if you didn't comply with those, it would have could have consequences to your case. And you haven't complied, and you would have gotten that again. You would have got that order sometime in early June. And now we're ordering on October. So the court is going to deny your motion for additional time. You can testify yourself in this particular matter, but as it relates to anything else that you should have produced, the court is going to deny that at this point. So that will be the order of the court. Mr. Daniel, you'll have to do an order denying her motion for additional time to present evidence.
Yes, sir.
Okay. Thank you. You're free to go. Have a good day.
You too.
Okay, court again will note the appearance of Mr. Robinson and the motion to change custody. Mr. Robinson, I hate to have you have to go through it again, but if you would just reiterate what you said previously.
Thank you, Your Honor. Our petition sets forth the material facts and the reasons why we believe it's in the child's best interest that custody be changed to his mother. Mr. Shelley was convicted of a fairly serious assault on his son last December, was placed on probation for 1.5 years. His probation was terminated 9 months earlier. He now wants back in the child's life, but the child is terrified of him. He doesn't want to talk to his father, doesn't want to see his father, certainly doesn't want to be with his father. And what we're asking for is a brief evidentiary hearing, perhaps with the parties only testifying, in order to establish the facts necessary to change the existing custody order.
Okay, thank you. Mr. Shelley, what's your response?
My response is I was wanting to try to get a termination adjournment till I can give me a counsel.
Okay,
I need a counsel at this point.
Okay. What we'll do is, again, I'll let Mr. Shelley have an opportunity to have attorney present. What we'll do is we'll adjourn the matter 1 week. So Mr. Shelley will come back in next week at the same time. So you'll need to have an attorney present at that time. Okay.
Okay. A week from today?
Week from today. Correct.
I don't really, I was at the point, I don't really want the son to be in her custody either. She's not supposed to have
Again, if I'm not going to let them argue stuff, I'm not going to let you argue. I'm adjourning it 1 week, 1 week to you get an attorney.
Kimberly Taft versus
All right,
Scott Murphy.
Okay, thank you.
Attorney Schaefer for the plaintiff and Attorney Capture for the defendant respondent.
Okay. Good morning.
Good morning.
Court will note that this matter is before the court on the defendant's motion to terminate the personal protective order in this matter. Only thing I would mention, Ms. Capture, as I was proofing and preparing this matter for today, your motion says see attached affidavit, and all the paperwork that I had from the clerk's office did not have an attached affidavit. So I'm going to need you to go into that because I have no idea what was in the affidavit.
Yeah, it's actually quite lengthy. Let's see. Yeah, it says we filed it, but it must have been. So I'm just going to read directly from the affidavit then, Your Honor, because it's quite lengthy, unless you want me to email it over to your office.
Nope, I'm not going to have opportunity to review it at this point if it wasn't done before.
It was filed appropriately with all of.
I understand. I just don't know where it broke down because I went back into the original motion and anything else, and there was no attachment. So
okay.
So,
all
but
right.
you can address that when you address the testimony of your client.
Okay.
Unless you're just doing it through offer of proof, Ms. Cash.
No, I'll go through the testimony with my client.
Okay. Do you have any opening statement to make at this point or not?
Well, yes, Your Honor, I just want to state for the record that this was filed appropriately within the 14 days. We do not believe that an ex parte order was justified, given the fact that there was no immediate or irreparable injury present. There was no threatening. There was no behavior even set in the petition that would bring a reasonable belief that any of the prohibited acts under MCL 600-2950 would be issued. So, Your Honor, I would request that the ex parte be dismissed at this point. And then in the alternative, if we get through this and you believe that there is a reasonable belief that one of the prohibited acts are to be committed, that we at least modify the personal protective order to allow for communication for parenting time.
Okay, thank you. Mr. Schaefer, any opening?
Yes, I'll respond, Your Honor. There was a lengthy verified statement with the petition for the PPO that includes a substantial number of times, and the coup de grace was on August 26th when great bizarre behavior took place, that the respondent shows up at my client's home before light on one morning, and then would not let her out of the driveway, blocked the driveway, beat on the car, scared her and the children substantially, then tailgated her all the way to the school, taking the children in, which caused great angst in relation to the minor children and my client. It appears that there were statements made at him at that time that to the effect of run me over, and there's a history of mental illness here where back in at least in January of 23 that he was diagnosed with great anxiety to the point that he was suicidal at that point. The other events include August 1 at the Battle Creek Country Club, where he was yelling at her and following her at an event that the boys were at. There were events when he was brandishing a weapon with the children, and that dovetails back into the August 26th, where he was sitting out in his car loading magazines of a weapon. And he, in fact, did have weapons in the car that were found later by the police when he was stopped. This is disconcerting. It's bizarre behavior that is exacerbated over the time period. There are other events that took place in relation to him going into the home of my client without permission during a time period of him showing up at her home, going through the trash and looking for documents without permission. There was going back to even 22 that he had assaulted her prior to the completion of the divorce. There is a myriad of problems here that justify the PPO, and we would ask that it be continued.
Okay, thank you. Ms. Capture, call your first witness.
Thank you, Your Honor. I'd like to call Mr. Scott Murphy.
Okay, Mr. Murphy, raise your right hand. We'll have you sworn in and we'll proceed.
Mr. Murphy, are you familiar with the allegations that Ms. Taft has brought against you regarding an incident on August 26, 2024?
I am.
And can you describe to the court what exactly happened from your perspective on that date?
I previously the night before wrote Kim that I would like to pick up the kids to bring them to school. And I suggested either meeting in front of her house or at the gas station or down the street from her house. And I got no response whatsoever via email or text that she would even allow me to pick the kids up, even though it was my parenting time. On the morning of, I left. I wrote her again, said, I'm on my way. Where would you like me to go? Again, I got no response. So I finally said, I'll be at your house, outside your house in about 15 minutes. Again, no response. So I parked outside on the street, waiting for her. Because I didn't even know she was going to give me my kids at that point. So then she came down. I saw her exit her driveway, her garage, and then she came out. and walked down and started saying, "You're not even supposed to be here." And I said, "Well, I didn't know where I'm supposed to go because you never answered my text, you know." And then she yelled at me that I need to leave, and then she was going to take the kids and not give them to me. So then that's when she tried to leave. I did block the driveway and then pulled forward, and then I ended up stopping the car. I got out and I asked her, I said, "Please, it's my time. I'd like to take the kids to school." And I was standing in the street, and then she drove the car up into me, right up against me, and was continuing to drive and move the car as I was against it. And I didn't say, "Run me over, run me over." She's yelling at me, "Move." And I said, "I cannot move. You're running me over." At which point I finally moved. I rolled off the vehicle. She continued to speed off. The side mirror hit me as she passed me, which pushed it in. And as I was rolling, I hit the window where the kids were to try to help support myself so I didn't fall over, which was where the kids were, but I wasn't hitting it repeatedly as it said. And then I drove behind them, but it's on the same way to go to school. And I do have audio recording of that whole incident where I said, "I can't move, you're running me over," to show that I didn't say, "Run me over, run me over." And then I proceeded to drive. The kids called me and said that they didn't want me to take them to school that day. And I said, "That's fine." And my route is the same route to go to school as it is for me to go to work. So I was behind them that way until I had to go to work, and I turned right. But I didn't tailgate them the whole way. I was no more than 2 to 3 seconds behind them. Came to a stoplight at Territorial and Capitol Avenue. I stopped 30, 40 feet back. And I have dash cam footage of the whole drive to show that I was never tailgating her the whole way. And then I arrived to work, and then I was approached by police officers after that.
Ms. Taft states that you were, you had a weapon on you in your possession. Did you have a weapon in your possession? Was it within hand reach?
No, the weapons were in the back of the vehicle.
In the trunk?
Correct.
And you said that was your scheduled parenting time?
It was. I allowed the kids to stay the night at her house based on an agreement we had to try to help the kids transition into moving in with me and my wife on our time.
And was there a reason why you were loading bullets into a magazine?
Finnegan, my son, wanted to go to the gun range later that day. So I don't have a whole lot of time with them based on the parenting time and me giving them up to stay the night with their mom. So those take a long time to load. So I didn't know how long it was going to take for her to come out. So I was just trying to utilize time while I was waiting to load those.
At any time did you threaten Ms. Taft?
Absolutely not.
Have you ever threatened your children with guns or Ms. Taft with a gun?
Absolutely not.
Ms. Taft talks about an incident on August 1st, 2024. Do you recall that incident?
I do.
And that was at a country club, correct?
Correct.
Can you describe what happened on that date and time?
They had just gotten back from a trip, so I hadn't seen them probably in close to a week. I had ordered water bottles for them that I wanted to give them. So I was on my way into work on a Thursday. They had camp for tennis. It's about noon. So I went in to go see them so I could hand them the water bottles. I was waiting in the car kind of to see if they had a break. Kim wasn't there at the time, but then she pulled up with her and her boyfriend, and they started walking in. And then it looked like the kids were getting ready to have a break, so I kind of walked in, but I tried to keep my distance behind her and him. But as I was walking in behind them, she says, "Not working on a Thursday, I see," which I responded to like not working ever to her. And then didn't really say anything after that. She went and sat, and I kind of waited in a different area. And then I saw the kids and hand them a bottle. And then I did say something to her like, "It's ironic you say something to me about working when you don't work at all." And then she left the car and came back. I didn't follow her out to the vehicle or anything. I stayed in the little patio area there. And when she came back in, she asked about, or I told her that I had the country club membership changed to my name, which is what it is agreed to on the divorce agreement, that I have to maintain the family membership. And she said, "Why would you do that?" And I said, "You're still able to take the kids in charge with the kids." And then she proceeded to call the kids over and say, "We can't come to the country club now because Dad took us off the membership." And I said, "That's not what I said." you guys can still come. And then that's pretty much how that altercation ended.
At any time, did you follow her around?
Not at all. I stayed inside the fenced area the whole time.
Did you yell at her?
No,
Did you threaten her?
no,
And you were solely there for the purpose of seeing your sons?
correct.
On June 9th, 2024, were you still married to Miss Taft?
Stay.
June 9th, 2024.
No,
Okay. Do you recall an incident with your son on that date? Just as a reminder, she stated that the child claimed that you were brandishing a weapon or of some kind.
yeah, that's blatantly untrue because I didn't even own a weapon at that point. I didn't have my CPL license until July 3rd. So I had no fire gun or firearms or ammunition or anything inside that apartment at any point.
On April 22, do you recall an incident between you and your son Finnegan regarding a Nerf gun?
Yeah, he was acting up, shooting his brother, shooting me. His brother asked him to stop. I asked him to stop. He continued to do it. He shot me. So I went and took it from him, grabbed it from him, kind of turned, put my shoulder into him and took it away from him. But I never slammed him into a wall or anything like that. And then he got upset and wanted to call his mom and go home.
Okay. At any time, did you threaten Miss Taft or show up to her home and act inappropriate in any way?
No,
Did you call her at all and yell at her or communicate with her in any way?
no,
Do you recall an incident that occurred on April 16th, 2024? Regarding the dog.
yeah. On the divorce agreement, it's supposed to be that the dog comes with the kids. But at some point, Kim just stopped following that part of the agreement and sending the dog with them. So I had taken the kids to try to get the dog, and they know the code to the front door, but they didn't. Apparently she changed the code or it didn't work, so they couldn't get in. So I just suggested they go try a door around the side to see if that was open, if they could get in to get the dog. But I didn't even, I think I parked on the street for that. I don't even think I pulled in the driveway for that.
Did you instruct the kids to break into the house at all?
No, I just said to check that door if it was unlocked, if they could go see if they could get in and get the dog.
Okay. Did you enter the home at all?
No,
Did you attempt to enter the home
not
at
at
all?
all. I don't even think I got out of the car.
On August 14th, did you enter the house? Were you still married? August 14th, 2023. Sorry, that should say 2020.
Yes.
You were still married 2023?
Mhm.
So were you a joint owner of the home?
I believe I was
The
still
marital
deed
home.
until December.
Okay. Would you go over to the home throughout the year when you were still married?
Mm-hmm.
Okay.
She would have me over to help with things.
Did you stay at the home
Mm-hmm.
with her?
Sir, when you say would you say yes or no? Because it doesn't pick up and designate whether that's and whether
yes.
it's yes or no. Thank you.
Yes.
Did Miss Taft during the course of the divorce proceedings at any time have exclusive use of the home?
I had moved out.
But was there any court order stating that you
No,
had?
there was nothing that prevented me from being at the house.
Okay. Had she ever told you, I don't want you at the house anymore?
She said she'd prefer me not to be there, yes, but
Okay.
not that.
But you would regularly go in
Right.
and out of the home with her?
But I
agreement?
wouldn't go when she was not there.
Okay. There were some other allegations regarding your past relationship of inappropriate romantic advances on Miss Taft while you were still married.
Mm-hmm.
Do you ever feel like you inappropriately advanced on Miss Taft during the course of your relationship?
No, I never tried to take advantage of her or willingly tried to violate her in any way.
But you did engage in, marital relationships willingly with each other.
Correct.
Ms. Taft did say something about you were accessing a trash can. This was, I believe, in January 2023, after the divorce was over. Did you access a trash can on the property at all?
Trash can was on the street. It wasn't on the property.
Okay.
So I did go through and trying to find out if the cancer diagnosis is actually real. So I was looking for a medical bill, but I didn't actually go on her property or take anything. And I spoke when the officer contacted me that she had called. He basically told me that I didn't break any law and be careful that she's just trying to get a case against you.
Objection, Your Honor.
Okay, sustained.
Mr. Murphy, have you ever threatened Miss Taft?
I have not, and I would not.
During the course of this divorce, you said that there's a pet involved. Did you ever try to take the pet and exert control over that in a way that would take away from her ownership interest in that pet?
No, I just simply I would ask her for her to send the dog with him, with the kids, and she would refuse.
Did you ever threaten violence on the dog?
No,
Did you ever threaten violence on the kids?
absolutely not.
Have you ever retained possession of the animal, or do you not get the animal at all
I
anymore?
don't get the animal at all anymore.
So she retains the possession of the animal despite the agreement between the two parties?
Correct.
It's my understanding that you have a concealed weapon license.
Correct.
Is that a condition of your employment at all?
No,
And you didn't receive that until July of 2024, is that correct?
correct.
Have you ever tried to remove the kids or any personal property from Ms. Taft's possession?
No,
You've abided by any court orders that you have regarding the two?
correct. Even when she hasn't handed them over since this ex parte parenting time has been denied, she's still not giving my parenting time, but I'm not fighting him on it just to not cause a scene with the kids.
When was the last time you actually entered onto the premises of Ms. Taft's property?
It would have been sometime early 2024. I was maybe on the driveway with the kids.
And are those entrances only for the purposes of exchanging the children?
Correct. Up until we started picking up at different locations.
Okay. And you've never threatened to show up at her home without her there?
No, I've said I can come pick them up at your house, and she'll say no, but I've never said I'm going to be at your house without you there. Absolutely not.
Thank you, Your Honor. I have nothing further.
Yeah, thank you. Mr. Schaefer, any cross?
Yes, please, thank you.
Mr. Schaefer, we can hardly hear you.
Oh, okay, very good. We'll get up close and speak right up. All right. Let's go to the August 26th event. You had been told by your ex-wife that you were not to come to her home. Is that correct?
We agreed on meeting at different locations, but there was no court order thing that I could not be there.
Okay, well, my question is, you were told by your ex-wife not to come to her home. Is that correct?
Told that I would prefer not to be there.
And you understood that, did you not?
I had abided to it.
Okay. And you guys had agreed to a neutral spot of exit 92 for the exchange of the students, the children, correct?
Or when it was time to exchange the kids, but not for, like, that would have been out of her way to do on a school day, and she wouldn't have done that on that day. So I was trying to get something that would be closer for her and more convenient for her.
And you never got her permission to go to her home, even though she had indicated that you should not go to her home, correct?
I never got anything from her because she refused to respond to anything. So I had no idea
And-
where to go because she wouldn't respond.
And she had indicated to you that the communication between the two of you should be by email, and you had communicated by email prior there too, had you not?
We had communicated via text and email. And then when she gets upset, she would switch to communicating only via email, which I would communicate via both and then via email. But I communicated that I want to pick them up the next morning via email and via text, and I got no response to anything.
Okay. On August 26th, you admit that you blocked her drive and she had to go around you onto the grass to get away, did she not?
That's correct.
And you followed her so close that you were tailgating her for a long time period when she was taking the children to school.
That's incorrect. Like I said, I have dash cam footage that shows I was never more than 2 to 3 seconds closer than her the whole time.
And at that time, it was dark out, was it not?
No, it was light.
It was
light.
it was sunrise.
Did you have your lights on in the car when you were following her?
Probably the daytime running lights were on.
And the children, you said that you got communication from the children that they were afraid and for you, they didn't want to go with you, correct?
That morning that they said they didn't want me to take them to school that morning. And I said, that's fine. I understand. I'm sorry that I scared you guys. That was not my intention.
Okay. And you, in fact, pounded on the car of Kim's where the children were at the time that you got out of your car, did you not?
As I said, she was speeding by me and I was rolling on her car. She hit me with her side mirror and I was trying to maintain my balance and I hit the window trying to maintain my balance.
Why did you get out of the car?
Because I was trying to have her, I was pleading for her to let me have the kids because it was my time and she wasn't going to let them come with me.
And you had not exchanged the children at the home for some period of time, had you not?
Correct.
Okay. How many weapons did you have in the vehicle on August 26th?
There were 3 guns in the back of the vehicle.
And describe those to us, please.
One was an AR-15. The other was a H&K MP5. And the other was a Ruger, like a long handle pistol.
And you had gone through some mental difficulties and you had gone to life coach psychology, had you not?
I had just had a diagnosis done there, or a test done there.
And do you recall what the diagnosis was?
Just major depressive disorder and general anxiety disorder.
Okay. And
Mr. Schaefer, I can't hear you. We can't hear you.
okay, sorry. Excuse me. You had provided a report of the psychological review to Kim at some point in time, had you not?
Correct.
And that was by a Dr. Harold Smith.
Sounds correct.
And at that time, you had reported pursuant to a report of 12423 that you reported engaging in problematical impulsive behavior. Do you recall reporting that?
I have ADHD as well, so that would have been part of that diagnosis, but I don't know what I had told him. I mean, I took a whole series of tests, questions, so I don't know what they interpret off of that, so.
All right. And were you suicidal at that time?
No, I've never been truly suicidal. I had maybe thoughts at my lowest, but nothing that would have ever even been remotely close to following through with.
When you applied for your CPL, did you advise the authorities that you had been under mental care?
Well, I'm not any of those. I mean, I see a therapist. I'm not under mental care that way. So I see a therapist. Kim sees a therapist. So I don't think that's a negative thing. Everyone should see a therapist.
My question was, did you report that to the authorities at the time of your application?
No.
Okay. On August 1st, 2024, the country club event, did there not come a time when you were yelling at Kim?
I don't think I didn't yell at her. I may have raised my voice a little bit, but she always raises her voice when she talks to me. So it's just.
So you may have raised your voice because you were not seeing eye to eye about whatever subject matter that was there.
Correct.
Did you follow her when she had gone out to the car?
I did not.
Did you intercept her when she came back from the car?
I stayed sitting in that pavilion area, which is, there's one entry and exit way out of that way. And when she came back in is when I told her that I had the country club situation taken care of, which she didn't appreciate. And then she twisted that into telling the kids that I kicked her out of the club and they couldn't go there anymore.
And what was your response when you heard that?
I told the kids that's not true, that they're allowed to come there and she's allowed to come there with them.
What was your response to Kim?
I just said that's not true. That's not what I told you.
In relation to the allegation on June 9th of 24, did you in fact, there come a time when Finnegan wanted to return to his mother?
There was 2 times that happened. I think that was the second time.
And if he reported that you had a loaded gun at that time pointing it around in your apartment, are you saying that's not true?
That's blatantly untrue. I didn't own a firearm at that time.
In relation to the April 22, 24 event at the Gethings Circle address, did you yell and scream at Kim at that point in time?
No, I mean, I was standing further from the car. I didn't go right up to her vehicle, so obviously I have to have my voice elevated so she can hear me, but I didn't yell and scream or in a threatening way.
And this was the time when you and Finnegan apparently had difficulty with a Nerf gun incident and the boys wanted to go with their mother. Is that correct?
Correct.
Okay. In relation to the April 16th, 24 event, when you were at the home of Kim's, you were present out there with the boys, were you not?
I was in the car.
Well, you were driving the car and you went to her location, did you not?
Correct.
Did you ask permission to go to her home?
I believe I wrote her and said that we were going there to get the dog.
You wrote her. How did you write her?
Text.
So you went to her home with the boys and you instructed the boys to go into the home. Is that correct?
Correct. I asked them to go in and get the dog since she didn't provide the dog.
Did you ever ask Kim if you could do that?
I think I wrote her and asked her what the code was so that we could get the dog when I was there outside.
And did she give you the code?
She said that the door was broken or something. I don't know. Made some excuse. That didn't work.
And so for whatever reason or interpretation, she never gave you permission to take the boys and enter the house.
Correct. Well, she just never gave me the code. She didn't say yes or no.
Okay.
I don't remember.
On January 18th of 24, you admit that you appeared at her home and went through her trash. Is that correct?
On the street, correct.
And you did that because you didn't believe anything about her diagnosis and you were looking for those papers. Is that correct?
Correct.
Did you tell her that you were going to go to her home and look through her trash?
No.
In August 14th of 23, did you go into the home where Kim was living without her permission?
I don't believe so.
Isn't it true that you had gone into her home a number of times without her permission?
I don't think that's correct. I usually don't go there when she was there.
In reference to an event of January 12th of 2022, did you inappropriately assault Kim?
I don't see it as an assault. I was consensual at my time. At the best of my knowledge, there was an incident a couple days before that was consensual as well. So I thought I was well within my...
Okay. Regardless of the prior consensual one, you got complaint from Kim about this sexual activity that you forced upon her on that date. Is that not true?
She may have said no, but she would often, anytime we would have any kind of relationship, she would always start out by saying no.
She
So
was
it's hard.
she was quite ill with COVID at that time, was she not?
She was sick, what I know.
And you emailed her shortly thereafter, and you admitted that you overstepped your bounds in that time. Did you not?
No.
And didn't you email to her? I wasn't trying to take advantage. I was just trying to make you feel good. I should have stopped. I'm sorry. I won't spin it. I was wrong and I'm sorry. Do you recall emailing that?
I believe it's a text, but it wasn't admitting to any kind of wrongdoing.
Do you admit that you text that message?
Yes.
Okay. No further questions this time, Your Honor. Thank
Yeah,
you.
thank you. Anything else, Ms. Capture?
Mr. Murphy, when was the diagnosis given? That was in January of 23, correct?
That sounds correct.
And that was before you and Miss Kimberly Taft were divorced, correct?
Correct.
And since that diagnosis, have you been engaging in therapy?
I go weekly or bi-weekly.
And do you have any medications prescribed to you?
I do.
And do you take those medications as prescribed?
I do.
And at any time, do you feel like you are a danger to the community, or does your therapist believe that you are a danger to the community?
Absolutely not.
I'm going to object to the opinion of the therapist, Your Honor.
I will sustain that.
And were you required under your CPL to state that you engage in therapy?
No, I don't believe it asked that question.
Okay. Again, throughout this entire period, obviously there was a contentious divorce. Is that a correct statement?
Correct.
And then there's also contention, to your understanding, post-judgment. Is that correct?
Correct.
Is it your understanding that there's primary contention regarding parenting time?
Correct.
How would you characterize yours and Miss Taft's relationship now?
Obviously very non-existent. I only want to contact her regarding the kids and pick up time and whatever needs they might have. I don't have any desire to have any kind of other relationship with her. I just want to be able to see my kids and be at their sporting events. And, you know, I help coach my youngest son's baseball team. And for this, I go to all their sporting events and I can't go to them now. And it kills me to not be able to go to do that. I would never, prior to this event, anytime in public, there was never any kind of scene with us. I've never once threatened her violence. I wouldn't ever threaten violence or do violence against her because I wouldn't hurt the kids in that way or her in that way. And it's just not worth it for me to have something happen. So.
Thank you, Your Honor. That's all I have.
Thank you.
If I may respond to a couple questions.
No, I don't need any more. Ms. Capture, do you have any other witnesses?
I have no further witnesses.
Okay. Mr. Schaefer, do you have any witnesses?
I would call my client to the stand.
Okay.
Raise your right hand, be sworn. Okay, Kimberly, speak right up. You've got quite a ways away, so kind of yell at me here so everybody can hear, okay?
Okay.
All right. You had made a lot of allegations in relation to your petition for a PPO, correct?
Correct.
And were those allegations true at the time that you had filed this petition? Yes. And let's go down through the last one, the August 26, 24 event. Tell me what happened on that particular day.
It started the night before, when the kids were going to come back to me that evening. Scott sent me an email, letting me know that he would not be bringing the kids to exit 92, which is where we normally did the exchange, that he would be at 88. And I replied back that 92 is where we had always been. That's where I felt comfortable because it was a public place. There were a lot of people. The exit that he wanted to meet at is desolate. There are no people around. There's no business around. It's just an empty lot, which made me uncomfortable.
What happened on the morning of August 26th?
That morning, when I was getting the kids ready to go meet Scott, I noticed that he was sitting in front of my house. I decided to walk down and ask him why he was there. When I got to the car, he was loading gun magazines. I asked him why he was at the house. And he stated because he could, and he was there to pick up the kids to take them to school. And I said, you know that you are not allowed here, and I need you to leave.
Had you told him not to be at your home prior to this date?
Yes, repeatedly.
And was there any question in your mind that that message had been sent to him that he was not to be at your home?
He knew that he wasn't allowed to be at the house.
And your agreed to exchange neutral place was exit 92, not exit 88? And so what happened in the morning? Did he leave at that time?
He did not leave. I asked him why he was loading the gun magazines. He responded, I can do what I want. I have my CPL. I responded back, no, you can't. You are scaring me and you're trying to intimidate me and I need you to leave.
At that time, I walked back up the driveway. Scott was yelling at me from his car. I got into the garage. The kids had come out of the house and gotten into the car. They wanted to know why Scott was there.
Okay, so you got in the car and did you try to leave your home at that time with the kids?
I backed out of the garage and drove down my driveway. And at that point, Scott pulled up his vehicle to block me from leaving the driveway. I then turned right into my yard and started to drive through the grass to be able to leave. He pulled up and sped up, so I couldn't. He drove me further into the grass. I eventually stopped quickly and was able to slowly try to maneuver myself around his vehicle. And at that time is when he jumped out. He started yelling at me to give him the kids. I told him he was scaring us and to move out of the way. I continued the whole time to inch forward. I was scared. And at one point, he moved to the passenger side of my vehicle. He hit my side mirror, made it fold in, and then he started hitting the window where the kids were sitting.
What was the reaction to the kids at that point in time?
Fitzpatrick, our 10-year-old, started asking, what is he doing? He's a psycho. And Finnegan, our 12-year-old, said, what is wrong with him? Why is he doing this? And I said, I don't know. And
did you eventually leave your property?
I did.
And did you get followed by Scott at that point?
I did.
And how far did he follow you?
All the way to the light at Territorial and 20th Street.
And how close was he traveling behind you?
When he began to follow us is when I called 911. And at that point, I was focused on driving and talking to dispatch. Fitzpatrick, our 10-year-old, is who said while I was on the phone with dispatch, why is Dad following so close? He's
Objection, Your Honor.
Okay, somebody else said. What did you observe? How close?
I observed at that point on 6.5 Mile Road that he was following extremely close to my car.
Okay, did you feel that he was tailgating you at that point?
Yes.
Okay, the next event that we allege is August 1 at the Country Club event. Tell us what happened on that day.
Dropped off the kids at their tennis lessons. I ran a quick errand and came back. When I came back and parked and began to walk into the facility, Scott got out of his car and followed behind me. I made a comment that I was surprised he wasn't at work at noon on a Thursday, which is one of the busiest times for our restaurant. At that point, he got loud and began to degrade me.
What did he say?
He told me that I needed to get a job, that I was worthless.
All right. And so was there more did he follow you any other time at the event?
Yep. I went and sat the furthest spot away from him. But after a few moments, I noticed that Finnegan had forgotten his baseball cap. So I went to go get it. The only way out from where I was sitting was to walk past Scott. At that point, he got up, began yelling at me, and followed me all the way to the parking lot. I went to the car, got the hat. I came in around a different way and tried to give it to Finnegan and went and sat further away from him.
Okay. The next incident we had, on June 9th of 24, did you get a request to pick up Finnegan from Scott's place?
Yes, I did.
And was he distraught, Finnegan distraught when you picked him up?
Yes, he was crying and very upset.
Okay. And the next incident is April 22 of 24. And that's at Gethings Road. And had something to do with an altercation about a Nerf gun. Do you remember that incident?
Yes.
And did you get a call to pick up Finnegan and Fitzpatrick at that point?
I did.
And how were you treated when that happened?
When I arrived, Finnegan came out first alone. He was crying. He was afraid that Fitzpatrick wouldn't come with him as well. He went back inside to get him and his stuff. And at that point is when Scott came out. I never got out of my vehicle. I had my window down. He began to yell at me that this was all my fault. He was screaming at me that I did all this. This is my fault. He repeatedly kept saying it over and over. He eventually went back in the home, in the apartment. I could hear him yelling at the kids. A short time later, the kids both came out crying and got in my vehicle.
Okay, the next incident is April 16th of 24, concerning the dogs at your house. Tell me what happened in that regard from your perspective.
A lot of times due to the children's sports, the exchange of the children would be done at their sports, which would mean I would not have the dog. He would, whenever he decided it fit his schedule, would then try to make plans to pick up the dog. On this particular day, I knew that they were at the house trying to get in because my Ring doorbell went off. And at that point, I called Scott on the phone and asked him why he was at the house, why he was trying to get into the house. And he stated that he was trying to get the dog. I told him as stated before, you're not allowed at the house, and the children aren't allowed at the house during your parenting time when I'm not home, and that he needed to leave.
What did he say to that?
I don't recall exactly what he said, but I had to state to him that if he didn't leave, I was going to call the police. And it was during this time where he had told the kids to go try to push through a door in my garage. This made me feel unsafe. I ended up having all of the locks changed again, which I had already had done after we separated, and now had done it again because I was afraid that he was going to come in the house.
Okay, and next incident is January 18th of 24.
Mr. Schaefer, I don't want to cut you
Yes.
off, but we're going long, and I've got a number of other hearings, and I think I've heard sufficient that I need in this matter.
Okay, very good.
So I'll let Ms. Capture go into any cross before we conclude.
Thank you, Your Honor. Ms. Taft, on the morning of August 26th, did you ever communicate with Mr. Murphy?
No.
You never sent him any text messages confirming that your location was going to be the typical exchange location, even though he asked you multiple times?
He sent an email to me stating that he would be at Johnny's near my home to pick up the children.
Did you explain that you would meet him there?
No, I tried to call him on the 25th after that email, and that is when he hung up on me. I tried to call him again, and he didn't pick up.
So it's your typical understanding that you communicate via email?
Yes.
And you refuse to communicate with him via email about parenting time exchange?
The conversation went from email to over the phone on the 25th. He stopped responding to me. He wouldn't take my call.
And you did not communicate with him via email on the 25th at all?
I did communicate with him via email on the 25th. It then led to a phone conversation, which started, he hung up on me. I tried to call him back. He didn't pick up.
But you did not confirm, again,
you
did not confirm that you would meet Mr. Murphy at the location that he emailed you?
I didn't reply to his email. I called him.
Thank you. Did you respond to any of the text messages in the morning that he sent to you?
I don't get his text messages, which he's known for quite some time.
So you co-parent with Mr. Murphy, but you do not communicate with him via text, even though that is something that he communicates with you on, because you blocked him, I'm assuming?
We stopped. I told him that I did not want to communicate via text anymore because he would obsessively text me over and over and over again. So we moved over to email.
And it's my understanding that you did not email him in the morning. I'm sorry, Ms. Taft. Just to clarify, you did not email him in the morning on the 26th?
I emailed him on the 25th.
Okay, but you did not email him on the morning of the 26th, correct?
I do not believe so. I emailed him on the 25th.
And what did you state in that email on the 25th?
It was regarding the pickup spot.
For the morning of the 26th?
No, for the 25th, for him refusing to go to our pickup location.
Okay, so you did not communicate with him at all about the exchange on the 26th?
No, because he wouldn't pick up the phone.
Okay. Ms. Taft, you talk about the altercation at the country club. You were the person to instigate the conversation with him about his work schedule on Thursday. Is that correct?
I made a comment to him, yes.
And you stated that he followed you in. What time was that at?
Roughly 12:30. I don't know for sure.
And was that around the time the boys were taking their break?
Not at that time yet.
But it was roughly around that time?
I don't recall what time they took their break.
Has Mr. Murphy ever, in the last year, threatened to physically harm you?
He has repeatedly put himself in situations that have felt very threatening to me.
But he's never threatened to harm you?
On the day of the 26th, by him sitting there and repeatedly loading gun magazines after I asked him to stop and I told him I was scared. Yes, I felt that.
Maybe I can rephrase to help you. Has he ever verbally threatened to harm you?
He said he could do what he wanted that day. So yeah, that was a threat to me.
Was that, okay. Did he have a gun in his possession that you could see?
There was a case, that's all I could see, but I was too focused on the fact that he was filling gun magazines throughout our entire conversation. It never stopped.
Okay. Your Honor, I have no further questions.
Okay, thank you. I don't need any more, Mr. Schaefer.
Okay.
Ms. Capture, any closing?
Your Honor, the code is very clear. To be able to satisfy, you need a reasonable belief that an individual will commit one of the sections under 62950. The last time Mr. Murphy entered or allegedly entered the premises was back when these parties were in the midst of a separation. He's never assaulted, attacked, beat, or wounded petitioner. He's never threatened to kill or physically injure her. He's never removed the children from her except by a custody and parenting time order. He is allowed to purchase and own a firearm. He has a CPL. Loading bullets into a magazine is not the same as threatening. It is not loading it into a actual weapon. No weapons were in his possession at the time, well, within his hand reach. They were in the trunk of a locked vehicle. Respondent has never removed personal property from the premises that are solely owned by petitioner. He's never showed up to her place of employment or education to interfere with her. He's never sexually assaulted her. He's never removed access to minor children's records or removed any access from petitioner's records whatsoever. He hasn't tried to exert any control over petitioner with regards to animals. He's never injured or tortured or killed an animal. He's never even removed the animal, even despite the fact that petitioner doesn't follow the agreed divorce consent judgment. The problem here is that these parties are engaged in a very tumultuous post-judgment divorce proceeding. There is numerous complaints that this has to do with parenting time. Most of the allegations have to do with parenting time. The parties don't agree, they don't see eye to eye, and this needs to be resolved in family court, not in a PPO. This is only further ammunition for Ms. Taft to continue to make a wedge between the children and Mr. Murphy. There's no basis at this point for a PPO. What needs to happen is these parties need to engage in co-parenting therapy. That's obvious. However, lack of communication is a strong indication that the two parties don't want to co-parent. Changing communication on my client to be able to pick up his children, that's an issue. One moment petitioner will engage in texting, next moment she'll phone call, the next minute she'll email. That's inconsistent and it causes confusion, which causes disruption, which inevitably causes arguments between co-parents. This is not a PPO situation. This is a failure and breakdown of co-parenting. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, this certainly is a PPO situation. The actions of somebody who is going through therapy currently, apparently, and back in 23, diagnosed with some mental illness, and shows up at my client's home unannounced, without permission, loading magazines of guns at 7 o'clock in the morning, is disturbing at best. Admittedly, not only did he have handguns, he had AR-15s in his trunk. When the nicety of it, not in my possession, not in my reach possession, but in his possession, is disturbing at best. We have heard too many stories the next morning of improper use by mentally ill people. That is problematical. We have heard testimony that there was a sexual assault, admittedly so, that he overstepped his bounds. Heard that he has been to her home without permission, whether it's to get the dog or coerce children to go into the house. This is problematical. We have heard yelling and screaming and threatening at country clubs at times when they are exchanging children. This is a PPO situation that needs to continue on for the safety of my client, and I would so request. Thank you.
Okay, thank you. Well, in this particular matter, the court and the attorneys have noted, and they've referenced MCL 600.2950, particularly the court can enjoin and restrain certain conduct if the court determines that there's reasonable cause to believe that an individual has committed or may commit any of the acts listed under MCL 600.2950 parens 1 parens A through K. There's been a lot of testimony, probably a lot more than the court needed in this case, about somewhat tenuous circumstances and times when they were still together. I don't infer or ascribe anything to the respondent in this matter when he entered the home at the time when they were still married and the home was still effectively at that time both parties, and both parties had access to it. There were other things as well. However, the court does note there was testimony, and that was corroborated and affirmed by the respondent, that on the occasion back on August 26, 2024, that he pulled into and did block the driveway of the home where the petitioner and the children were attempting to leave. A different interpretation of the events that ensued, but notwithstanding that, he did block the driveway. He noted as well that on a date that he was in the vehicle, his vehicle, and I think it was a different date, but it sounds like it was the same date, that he was loading the magazines for a gun, and he didn't have the gun present. He had the again, the magazines and apparently the bullets, and he was loading that. Court will find in this matter that again, in pulling into and blocking the driveway, making her go out into the yard, was in fact subsection A, entering upon the premises. The court will find that again, the situation of loading bullets when the other party is present and then stating, well, I can do what I want, would characterize an activity under sub K, other act or conduct that imposes or interferes with personal liberty or causes a reasonable apprehension of violence. Again, a lot of the things in this case as interpretation. Was the person yelling? Were they not yelling? Were they raising their voice? Things of that nature. But again, these two instances that the respondent acknowledges would fall into the parameters of placing a person at reasonable apprehension, again, in this particular case. As a result, the court does believe that it is appropriate that the personal protective order continue. The court would make I guess you'd say, a amendment to that, which would allow the respondent to contact the plaintiff vis-a-vis email, because apparently that's what they were using for a purpose of, or basically for specific child-related matters and for issues of parenting time. So the petitioner, oops, we lost.
I think we lost Mr. Schaefer.
Yeah, we lost him.
Right when you are on a roll, Judge.
Maybe he didn't like what I was saying at that point.
Mr. Schaefer?
I got everybody back on again, correct.
Okay. So the court will continue the personal protective order, but allow the contact for purposes of specific child-related matters and for parenting time. So Mr. Murphy, you can contact her by email for those purposes, but those purposes only. So don't go outside the realm of that. Don't call her with the idea that you're going to discuss a child-related matter, then get off on tangents on other things, because that would be a violation. But the court would allow you to, again, address child-related matters. For instance, the children were sick, or, school activities or things of that nature, or for parenting time, and that's it. So the court will make that modification. We'll get that entered and out to the parties. So you're free to go. Have a good day.
Thank you.
Eldred for the prosecutor's office and Attorney Sackletter for the public defender's office.
Okay, this is a time and place set for the plaintiff's motion to enter or to extend the PPO and to show cause for violation of the PPO in this matter. I guess I'd say, Mr. Eldred, are you ready to proceed? I know it's probably getting a little late. Obviously, I had Mr. Schaefer and Ms. Capture on the last case, and they got a little bit of verbose, let's say.
I wouldn't be surprised by that, Your Honor. So I haven't had a chance to speak to counsel about whether there's a resolution or not, and I haven't had a chance to speak to Ms. Mekediak. So
you got a lot of talking to do.
Yeah, and perhaps it might be a good idea to adjourn today and reset it if we could. Okay,
Mr. Sackler, do you have any problem with an adjournment?
No objection.
Okay. The court will adjourn the matter. Would a week or 2 weeks work best, Mr. Eldred?
Probably a week would be fine by me, Your Honor. 2 weeks.
Sackrider?
Let me check my calendar. I have no objection to that.
Okay, then the court will adjourn the matter and we'll take it up next week, again at 11 o'clock a.m.
Very good. Your Honor, Mr. Mekediak has received notice. Because I didn't have a copy of the notice to him.
Well, there was an order for alternate service in this matter, and it's
Very
my
good.
understanding that that was accomplished.
Very good. Would it be possible to be in a breakout room with Miss Mekediak for a moment? I know.
Okay,
And I
we'll put the two of you in a breakout room, then you can contact Mr. Sackrider
Yes,
some other time before next week.
we see each other daily.
Okay.
Yes, and we'll send you the renotices for next Monday, the 7th. So one moment here, Mr. Eldred, go to, and Ms. Makita, go to room number.
Mr. Eldred, I don't know who I should feel sorry for when you say you talk to each other each day.
Probably Mr. Sackrider.
Okay, we'll see you next week.
Okay, thank you.
Court will note the appearance of Ms. McNiff on behalf of the petitioner in this matter and the defendant representing himself. Is that correct, sir? You're going to be representing yourself?
Yes.
Okay. Ms. McNiff, do you wish to make an opening statement in this matter or proceed to proofs?
We'll proceed to proofs, Your Honor.
Okay, sir, you can make an opening statement or you can reserve on the opening statement or waive your opening statement. What do you wish to do?
Well, I'll reserve it.
Okay, thank you. Ms. McNiff, call your first witness.
Ms. Galt.
Okay, Ms. Galt, we have you raise your right hand, be sworn in, then okay, go ahead, Ms. McNiff.
Thank you, Your Honor. Ms. Galt, you filed a petition for a personal protection order against Mr. Schmidt?
I did.
And can you tell me what happened on August 9th between you and Mr. Schmidt?
August 9th, there was an incident that took place that Kyle was hitting my vehicle, yelling at me, trying to ask to speak to Ben, which I told.
On August 9th, or did that involve a message on Our Family Wizard?
Oh, I'm sorry. That was the wrong incident. I apologize. Yes, there was a message sent to me by Kyle Schmidt on Our Family Wizard about saying he needed to know the full names of everyone parked in my driveway. And he also needed to know who was driving the white vehicle in my car.
And why did that concern you?
It made me known that he is watching my house. And because there is a white vehicle that is in my driveway that is a family member's, but hadn't been there for at least a week prior to that. So
do you know where Mr. Schmidt lives?
In Galesburg.
And do you have any reason, was there any reason for him to be at your home?
No.
And is your home located on a major thoroughfare?
It's located on a crossroad, yeah, a road that is used for traffic.
And when was the last time, if any, that Mr. Schmidt was at your home for a sanctioned reason?
It's been at least 5 years.
And so why did that message concern you?
He has no reason to be at my home or by my house.
Okay. Does he pick up the children at your house?
No.
Have you ever wanted him to pick up the children at your house?
No.
Okay. And you have 2 children together?
I do.
Okay. And was there an incident that occurred on August 22nd?
Yes.
And what was that incident?
That incident was one where Ben was refusing to go to parenting time.
Excuse me, 1 second, Ms. McNiff, just to follow along, I've got an incident that occurred on September 5th, August 29th, and August 9th. I didn't have anything in the petition for the 22nd. And
Oh, well, then
that?
I'll withdraw that question then, since it's not in the petition.
Okay.
Was there an incident that occurred on August 29th?
There was.
And can you tell me about that incident?
That incident was one where we were at a custody exchange and Ben was refusing to go. I calmly told Kyle that Ben was refusing to go and not wanting to speak to him. Kyle then proceeded to hit my windows of my car and continued to escalate and raise his voice. During this time, I was inching backwards to try to leave. And he continued to stay by my car. I inched backwards again, 1 to 2 inches. And he proceeded to start yelling that I hit him, even though I did not. And we made a statement to the police. They did an investigation and I did not hit Kyle. So that was falsely.
What windows did he hit?
He was hitting my windows.
Okay. And where was your child located?
During this time, he was afraid. He was hiding in the back hatch of my car. He came forward to the front of the car and he was cowering down between the seats because he was afraid.
When Mr. Schmidt was hitting your window, was he saying anything?
He was continuing to say that he needed to speak to Ben, to which I told him that Ben did not want to speak to him.
Did you roll your window down or was it up?
I did roll my window down, so it was clearly heard.
And how far was your window down?
maybe 2 to 3 inches, because he had reached in my vehicle prior to this. So I was not allowing my window to be rolled down more than that to put myself into a dangerous situation.
And how hard was he hitting the window?
Enough that it could audibly be heard in the car by my son, and it was hard enough that it was not lightly hitting my window. It was hard enough that it felt aggressive.
So it wasn't knocking?
No, it felt more aggressive than that.
Okay. And was there anything else with regard to that particular date that happened?
I was extremely fearful because I didn't know, with him hitting my window, what was going to happen next, and I was afraid.
And you said you made a report to the police. When did you make the report to the police with regard to that incident?
We drove directly down to the police station.
Okay. And you also indicated that there was an incident on September 5th?
There was.
And that was this year as well?
That was.
And what happened on the 5th?
On the 5th, I again tried to de-escalate, calmly say that Ben did not want to speak to him and was refusing to go to the visit. Again, Kyle continued to hit my window, aggressively. You could tell he was visibly mad, and I was trying to leave due to this. My son was again fearful. I was fearful. And once I rolled up my window, and he would not let me leave and was trapping me where I couldn't move my vehicle again.
How did he trap you so that you couldn't leave?
He was standing within inches of my car.
In front of it or in back of it?
Right beside me at my driver's side door.
Okay. And what resolved that you were able to leave?
I got on the phone with the police because I felt like there was no way that I could get out of there safely. When I got on the phone with the police, he charged back to my mother's vehicle. I was on the phone with them and I could not see clearly what he was doing, but I later found out that he was telling my mom that he was going to go to her house.
Well, and let's not say anything.
In regards to me, though, he was still not allowing me to leave and entrapping me in my vehicle.
So when he went back to your mom's car, that allowed you to leave?
I was still on the phone with the police, yes, and assessing the situation.
Okay. And there's been an order entered by Judge Kirkham that prohibits Mr. Schmidt from being within 20 feet of your car. Is that accurate?
That is accurate.
And has Mr. Schmidt maintained that distance?
No, he has not.
And will the police enforce that?
I was told by the police that was not enforceable under a family court order, and the only way that it would be enforceable was if it was in a restraining order.
So what kinds of restrictions are you asking the court to put into place in a personal protection order?
Everything that I requested in my original petition, and I would also like to request that all exchanges be at the police station, as well as it be maintaining 20 feet away from my vehicle at all times.
And you currently have an order that requires all exchanges at the police station, correct?
Yes.
So are you asking that there be a restriction in the PPO that Mr. Schmidt must maintain a 20-foot distance from you?
At all times during the custody exchange, that would be accurate.
I have no further questions.
Okay. Mr. Schmidt, do you have any question of Ms. Gall?
Yes, you said on August 5th, there wasn't an incident in your report. It says August 5th. It's September 5th. Also on the 29th, the 5th, and the 22nd, I have video footage of the incidents. It appears that I do not.
No, sir, this is your time. This is your time to ask a question, not to testify.
Okay. So on August 9th, when I approached your vehicle, you say I was pounding on your windows. In the video, it says that it shows that I'm not pounding. How was I pounding on your windows? I was tapping on them.
I didn't state pounding. I stated that you felt like you were aggressively hitting.
How do you know I was aggressively hitting your window?
It didn't feel like
just your assumption.
This is how I felt.
Okay. All right. So on let's see. On August 29th, you says I entrapped you. How would I entrap you if I'm standing next to your vehicle trying to do a custody exchange to speak to my kid?
I was backing up, inching backwards.
So I was standing behind your vehicle or beside of it? That's not entrapping then.
I wasn't.
I'm sorry, what's that?
Yeah,
I'm objecting.
It's your chance to ask questions, not to, again, editorialize or anything of that nature. So you'll have a chance to testify.
Okay, so I was standing next to your vehicle and I entrapped you then, you were saying?
Yes, I was inches away from my car and could not safely back up. I was inching backwards and was not able to move away from, I was not able to back up
So I would have to be behind your vehicle to entrap you, correct?
No, I couldn't safely move backwards from my vehicle because you were standing so close.
Interesting. So, because on November 5th, you hit me with your mirror. I have it on a video. Did you remember recalling saying I hit your vehicle and you said I'm backing up after I stated I hit you? If in the video you would say I didn't hit you if you didn't hit me. You just said I'm backing up.
I didn't hit you. It was investigated by police.
Do you recall a video ever seeing at the prosecutor's office?
It was investigated by police, and I did not hit
Okay,
you.
and the police indicated that you didn't intend to hit me. They stated, correct?
Your Honor, it's both hearsay and not a question.
Sustained. You can't say what somebody else said, sir. Only what the parties, either the petitioner or yourself said, but not other third parties.
Okay. So you stated on the 29th I kicked your vehicle. Do you have a footprint that's on your vehicle?
It was witnessed by Benjamin.
Okay, so you're here to testify today?
I am.
Okay, so you didn't witness it. You just assume that I kicked your vehicle?
It was witnessed by Benjamin.
Okay, well, he's not here today. Let's see.
To clarify, ma'am, so you didn't witness that.
I had my eye on my peripheral vision, and he was right there. But
Okay, that's not what I asked. I asked, did you witness it? Okay, thank you.
No, sir.
Okay, then you also stated on another date, I believe on the, let's see here, just going over my notes. On September 5th, you said I entrapped you. How did I entrap you in your vehicle when I was standing next to it?
Again, you were inches away from my vehicle, not making it safe for me to back up safely, which is why I called the police.
Entrapment would be standing behind your vehicle, right? So that means it would be blocking you with a car, a physical person.
To be able to turn my wheel and safely back up, I was unable to safely back up. And because you were inches from my car, I was entrapped in the parking space.
No, that's not the definition of entrapment. On August 29th,
sustained.
On August 29th, you had bumped your vehicle into my wrist. I have it on video, correct? I was videotaping on the 29th.
I'm unaware if you were or not.
I was holding my phone in your vision because I remember you seeing me, correct?
I saw your phone, but I wasn't aware of if you were videoing.
So when we see the video, will it show that I kicked your car in the video then? Will it show that I entrapped you on the 29th?
There was multiple questions. What was the question?
In the video on the 29th, will it show that I entrapped you?
Yes.
Will it show that I kicked your vehicle? Because you clearly said a second ago that you didn't see me. So would it show it in the video?
I haven't seen the video, so I'm unaware.
The prosecuting office has the video. You haven't reviewed it?
No.
Okay. Then you speak about August 9th that I drove by your house. So you physically seen me drive by your house?
Due to you stating that there's a vehicle that is parked in my driveway, that would lead me to believe that you have driven by my house.
What road do you live on?
Correct?
And that's a pretty busy road. There's lots of stores on that road, right?
Correct.
And from Galesburg to Battle Creek, that is a main route to get there, other than the highway when there's construction, correct?
Correct.
Okay, so you didn't visibly see me drive by your house then, correct?
Due to you stating you needed the full names of everyone who was been in my parking lot?
Ma'am, that was not the question.
Oh, I'm sorry. I apologize. I have not visibly seen. No.
Okay, so you haven't seen me. So on the week of August 5th through the 9th, are you aware of numerous marks on Benjamin's legs and arms?
Objection. That has nothing to do with the allegations.
Yes, it does. It has to do with the messages that I sent her asking who's at our house watching Benjamin.
Well, it's not for purposes of this proceeding. I mean, you can testify that why you did that, but it's not germane to this.
Okay. So are you aware that my mother has a doctor in Battle Creek that she goes to, correct? You saw her at the hospital one time when you were working?
I'm aware that.
Okay, so you did see her before in Battle Creek?
Yes.
So is it possible for anybody else to drive by your house and state to me that there was a white car in your house, correct?
I don't know. Possibly.
Well, it's a yes or no question.
Well, she answered it. She said possibly.
Okay. So I think that's all. I have nothing further.
Okay. Ms. McNiff, any redirect?
Briefly, on the date when you indicated that you believe that Mr. Schmidt kicked your car. Did you hear anything that would have indicated that he had come into contact with your car?
No, I did not.
And Mr. Schmidt indicated that he has been videoing you. Is that accurate?
That is, he's been holding his phone up. I believe it could be video or photo. I'm not quite sure of either which one.
And have you had any discussion about him taking the videos of you?
Yes, I've asked him to stop.
And has he stopped?
No, he does not stop.
And how does that make you feel when he's taking videos of you?
Fearful, afraid, and unsure of what it could escalate to.
On video?
Sir, no comments.
I have no
Sorry.
further questions. No.
Okay, you have right to recross, sir. Only as it relates to items that Ms. McNiff went into on her redirect.
So, Ms. Galt, when we were at the Shell station in Battle Creek, are you aware that's a public place?
I'm aware.
Are you aware that you can videotape in a public place?
I am aware, but I asked you kindly to please stop. And
Okay, that's not the question. Are you aware it's a public place and you can video?
I'm aware.
Okay. So if you were fearful and there's a video being taken, wouldn't that make you feel safer because it's on a video that somebody could actually review if they requested, if you felt unsafe? That would make you feel safer, correct?
No, it did not make me feel safer.
But it's on video. It's a recording, right? That would show the incidents that happened. There's 4 of them that I have. Is that correct? That you've asked me once to stop videoing, correct?
I was unsure if the situation would escalate, and it did make me feel fearful.
But how can you predict the future of what's going to happen? Can you read minds?
Objection, Your Honor. Argumentative.
Sustained. Just address the facts, sir.
Nothing further. Thank you.
Okay, thank you. Ms. McNiff, any other witnesses?
I have no further witnesses.
Okay. Mr. Schmidt, do you wish to testify?
Yes.
Okay. Raise your right hand, sir. We'll have you sworn in and then we'll proceed. What would you like to tell us, sir?
On August 22nd, August 29th, and August 5th, I did video record the exchanges due to her not releasing my son to me. And I do have her on video. I did not entrap her. I did not hit her vehicle as she claims. I did not kick it. I tapped on the window. I knocked on it and asked to speak to Benjamin. Once she refused, I would say, well, it's not your choice. Can I speak to Benjamin? And she would want to roll up her windows and ignore me. I'm there for an exchange. I don't feel it's correct what she's doing. I believe that's all.
Okay, thank you.
You're welcome.
Ms. McNiff, any cross?
Mr. Schmidt, have you spoken with Ms. Galt's mother at on September 5th, 2024?
It states on a PPO it has to be Rachel Galt we're speaking of.
Ms. McNiff, I think he's making a relevancy argument. How is that relevant?
In the petition, Ms. Galt alleges that Mr. Schmidt threatened to go to her mother's house on multiple occasions and threatened to stalk her mother's house.
I believe her mother can file a personal protection order if this did occur.
Yeah, I'm only going to pertain to these parties. Okay, hold on. I'm only going to address issues concerning these parties, not third parties.
Okay. I have no questions for Mr. Schmidt.
Okay. Any additional witnesses, Mr. Schmidt?
I'd like to show you the videos.
Okay. Well, you're going to have to share screen and do that.
Okay. Let's see here.
No, sir. Let me say I don't think I need that at this point. So,
Okay.
We'll go ahead. Any closing argument, Ms. McNiff?
Your Honor, we are simply asking that this court enter a PPO that would restrict Mr. Schmidt from any stalking behaviors as are listed in item 5E of the petition, that he be prohibited from going to Ms. Galt's home, and that he be prohibited from interfering with or using any efforts to remove the children or any personal property from her premises. At this point, she is, and of course, he'd be prohibited from assaulting, attacking, beating, molesting, or wounding her. These parties have a long storied history of domestic violence and conflict, and these attempts at parenting time exchanges have escalated to the point where she is fearful, and Mr. Schmidt has been engaging in behavior that would cause her to be fearful for her safety, her physical safety, and we would simply ask that the court prohibit him from being able to continue to intimidate her.
Okay, thank you. Mr. Schmidt, any closing argument?
Yes. As far as she requesting stalking, I have never attempted or would want to stalk Mrs. Gall. I have never showed up at her residence in 5 years, she had stated. As far as removal of the children, I've only picked them up at exchanges, and that's it.
Okay, thank you.
You're welcome.
Well, in this case, the court has to look at the statute which is involved, and that's MCL 600.2950. And the court can enjoin and restrain certain conduct if the court determines there's reasonable cause to believe that an individual has committed or may commit the acts listed under MCL 600.2950 parens 1A through K in this matter. First, it's been alleged she's fearful of him entering the premises. However, she did acknowledge in her testimony that he had not been to the premises for about 5 years. Obviously, so there's no fear of entering upon the premises. She says she's fearful. First, she's fearful of the videotaping, but the point that Mr. Schmidt makes is appropriate, that if he's videoing it, then she should feel safer, not feel unsafe or fearful because of the fact that it's all videoed and all records. So the court doesn't, believe that that's appropriate under sub K, where she might, in fact, cause reasonable apprehension of violence because somebody is videoing her. She may not like it, but that doesn't mean that there's going to be any, violence as a result of that. In fact, the court would believe, as did Mr. Schmidt, that it'd be less likely to be any particular violence. She claims he hit the window. He claimed I was tapping on a window to get her attention. The court has, through the ex parte order the court entered, has taken care of that by keeping him 20 feet from the car when the exchanges occur in this particular case. The court notes that the other objection, nope, you guys are done. It's my turn now, Mr. Schmidt.
Okay.
The court does note that she states she hasn't seen him. She's never seen him go by the house, so she can't claim that he was engaged in stalking behavior. He did raise the point, maybe somebody related to him that they saw a vehicle at her house. That doesn't denote that he, was engaged in any behavior which would be stalking under the applicable statute. The court in this matter does believe that court's taking care of the issues that would be germane in this matter about being next to her vehicle, and believes that that is taking care of the matter. I don't believe that it's appropriate nor necessary to enter a PPO. I will deny the petition for entry of PPO at this time. So you're free to go today and have a good day. And we will be in, obviously we'll see you at some point in the future.
2024-2355 CB. Buzz Enterprises versus Zupa Global. Attorney McLean for the plaintiff. No, the defendant is not here.
Okay, Mr. McLean, enlighten me. What's happening?
Good afternoon, Your Honor. Dan McLean, P72982 on behalf of Bud's Enterprises. Yes, Your Honor, this is a date and time for the first status conference in this matter. We have obtained service on all defendants. However, our default dates that I have listed in my file are October 4th and October 6th. Unless we hear something by the end of the week, we'll be filing those. I would just ask if the court could set this over for maybe 30 days. Maybe this is closed in the meantime.
We'll reset it for 30 days, and then we should have more idea on what's happening.
Perfect. Thank you, Your Honor.
Okay, we'll let you go. Have a good day.
You too. Thank you.
Okay, 7 p.m. Attorney Jennifer Reed for plaintiff, Attorney Michael Kelly for defendant.
Okay, good afternoon to both of you. Afternoon.
Good afternoon.
Ms. Reed, what are we arguing about with Brad's?
Custody, parenting time, child support, spousal support, property, and debt division.
Okay, so everything.
Yep.
Okay. And I take it, because you're arguing about all that, you need some discovery.
That is correct.
Would you be able to get done by, that's early on, but would you be able to get done by December 1?
Yes.
Mr. Kelly?
I believe so, Your Honor.
Okay. Okay, we'll set December as mediation month. Who would you like to mediate?
Mr. Brundage?
Mr. Kelly, do you have any problem with Mr. Brundage?
No, Your Honor, he's fine.
Okay, thanks. Who is an alternate?
Ms. Podolsky?
Okay, is that fine to put her down as an alternate?
That's fine.
Okay. What I'll do is I'll set the settlement conference date as, let me see. January 13th.
Already scheduling in January.
Yeah. At 1:30 PM. Parties are required to be present unless we come to a full resolution prior to that time. Yeah, we're starting to schedule our trials actually in January. We're pretty much filled up this year.
Oh my,
Yeah. Anything else before we let you go?
I don't believe so.
Okay, we won't keep you any longer then. You're free to go. Have a good afternoon.
Thank you, Your
Thank
Honor.
you.
Yeah, Attorney Gazal for the plaintiffs, and nobody's here for the defendants.
Okay. Ms. Nizal, enlighten me. What's happening in the case?
Good afternoon, Your Honor, and may it please the court. This is a complaint to quiet title with respect to a property located on 1007 Industrial Avenue in the city of Albion. Per my understanding, Your Honor, the defendants have recently retained their attorneys. They have not returned the acknowledgement of service for filing, but they had indicated that they will do so sometime within the next couple of days.
Okay, well, what I thought is, what if we reset this for 30 days and hopefully we'll have everybody in at that point and we can see where we're going.
Thank you, Your Honor. So 30
Okay.
days from today's date?
Well, we'll do it on a Monday, so I don't know when it'll be, so.
All right. Thank you so
We will
much.
send
Your
out
Honor.
notice and we'll see you then. You have a good
Thank
day.
you. Have a nice afternoon. Bye-bye.
Right,
Bye.
thank